Lordship, I'd like to mention for listing of an anticipated bail on Monday, Lordship, the urgency is there, Lordship. Young boy fall in love with a girl, Lordship. The girl was on Monday, Lordship. Hello.
Maybe, Lordship. I beg to mention for Lordship, because there is a request for item number 21. I think it's what you are.
Another day.
No, equation, I find that.
Okay. It will be brought on record.
Maybe take it at 2 Lordship.
Yeah, in any case, it will be after 2.
Yes.
Mayor, I recognize us after listing of the previous available. Can it be on today or
Today. You can try. Time permits.
I don't know. I did not consider.
14.
48.
48. On the list. Diary is not received. Not received. Issue fresh requisition. List. You can suggest it.
6. Accept all the 6. I think not one. And then 9.
20 is a holiday, 19.
9.
19.
May I please? I beg to mention for listing for bail application on Monday, Lordship. The matter was filed on 5th
BA.
regular bail.
May please, Your Lordship. Lordship, I beg to mention item number 4 of the DD list. Lordship, we had filed an additional affidavit, Lordship. The same may be called.
It is a Lordship. Lordship, I beg to mention item number 38, Lordship. Lordship, whether case bearing was called for, Lordship. It might be available, Lordship. Lordship, conducting counsel is out of station, Lordship. Lordship, kindly.
Another day.
Another day.
CD is received. The CD receipt be written. The prayer of the learned counsel. Submitting that the leading counsel is out station. Then matter is adjourned to list on. It's it another day.
After vacation.
No, let it be on 22nd.
Lordship, interim order passed earlier.
Yeah, that's why CD has to be retained. Should not be the interim order shall continue. List on 22/9.
Number will be listed on
May it please the Lordship. Lordship, I beg to mention item number 17, Lordship. This matter may be come up before appropriate bench, Lordship. This was earlier rejected by.
No problem. 17, I think 17. The prayer of the council. Learned council, the petition, the matter is directed to be listed before another bench.
May I please, Your Lordship? Item number 20, Lordship. I file an explanation.
Affidavit should be brought on record.
May I please, Lordship? So I beg to mention item number 41 and 42. Both of these matters may come up any other day, matter. Next week, any day.
41 and 42.
41 and 42.
CD receipt.
CD received.
Next week,
Next week, any day.
17.
Interim may be continued as well.
Interim shall continue, will be fixed on 17. The case diary be retained.
All right.
May I please, Your Lordship?
Criminal petition.
But file for washing of proceeding. Notice was issued to be important. Since Lordship, 3/6.
It has not been missed.
Any things.
Let it be on 19.
One more pairs will be done. That means.
Huh.
Long time.
Criminal appeals before this bench. Those are other benches also taking up criminal appeals. Okay. Take it.
May I please, Lordship? Lordship, I beg to mention for listing on AV, Lordship, on Monday, Lordship.
Which item number?
Please.
Oh, for
Listing,
listing.
Lordship.
Okay.
on Monday.
And read about it. Item 57 option. Supply list. Supply list. Have you taken up with item 54 also? There is no. Take it out with 30. And check the microphone. Can I? Should be proper volume. Put that together.
53 days in custody. Period of detention is maximum 60 days. And also the main accused has already been released by another court.
He has completed 60 days.
53 days. 53. And main accused has been already released. And Lordship is aware, Lordship has already gone to the city that regarding fake appointment in forest department. And petitioner is a very sick person, he is in hospital. I have given the medical document also, last document also. And that is why Lordship asks the government advocate to take the instruction with the health condition. Yes, no, I have.
Medical documents do not indicate serious illness. It indicates health problems.
Also,
Low backache,
low back. Lordship, he has some difficulties. He's
type 2 diabetes,
type 2 diabetes.
systemic hypertension, hypothyroidism. These are not, not light problems, but
But considering the period of detention, Lordship, he should be released.
what is
Lordship, we can be space for this regarding jail state, health security from the jail authority. Just now I have received my WhatsApp. Lordship, I'd like to point out page 46.
page 46 of
Page 46 of the petition. Page 46.
okay.
Page 46.
It's an order.
Yes. You Lordship, make it.
Para 8.
Yes. 6, 7, 8. There is the case diary, and it is seen that 18 numbers of appointment letters allegedly paid has been seized by so and so on perusal of the statement of witnesses, some of who are recipients of the sealed appointment letters. It is seen that they are including details that they have given money for the purpose of securing the service to the forest department. We have statement of one witness who stated that accused who is in the present accused now with rupees 50,000 for the purpose of providing job to his daughter in the postgraduate grade 3 in the forest department. There are also incriminating details against accused who is saying that he printed the appointment letters in a place of Coloma Road, Melbourne. So considering their lesser and gravity of the offense. Lordship has already recorded that facts in para 12, page 56. Lordship has already recorded that fact after going to the city, page 56, para 12. My submission is that considering the period of detention, 53 days, 60 days is the maximum, and main accused has been released on bail by this another court also.
What is the stage of investigation?
This case diary is not
received. This is only the health report.
Yes, my health status report I have received.
Did we call for the case diary?
Lordship,
Updated
already
status
considered
report.
with case diary.
Updated since you are seeking subsequent bail. The updated state of investigation.
Lordship and the city, I have given the another copy given by another court, where court has recorded. Lordship can be para 5. Learned control submits that the offense alleged the case petitioner may be detained behind the bar. Investigation to simulation maximum period is 60 days. Only and he has already 53 days. Here also 53 days. And behind the bar,
The length of detention is not the only factor.
Length
It's a
of
very,
detention,
very
second
serious
level.
allegations.
can you
and-
see last portion?
Investigation has to be seen.
The last portion, para 8. Considering the period of detention undergone by the petitioner 53 days as well as progress made by the investigation, this court is considered opinion of further custodial interrogation of petitioner may not be necessary. For
That is the view of one point.
Lordship, on this count, Lordship,
That is
considering the illness and the 53 days, Lordship, 60 days is the maximum period.
No, it's you get the updated status of the case diary. Because the main grounds
Lordship-
is length of detention and health problems.
Lordship, case diary is already there, Lordship. On last occasion, it was disposed of on the Lordship. I have on 8/9/2025. It is already recorded.
It's a, you get the case diary. It may be available. You procure the case diary.
I'll get the instance.
You can take it up in a second. You get the case diary.
If case
Because, his contentions are length of detention, and health conditions. The the materials regarding health do not indicate life-threatening situation. You know, secondly, the length of detention depends, you know, what view you take. You know, there may be a risk of many things. Oh, yeah, it may be available only day before yesterday. So that we'll see. And we'll also take this into account. It's not that ordinary benches passed, but in bail matters, it's different accused have different situations.
I understand. Also. Only thing is also kindly see page 25. My commission. Page 25.
Look at think of the gravity of the allegations.
Not say page 25. This page 25. The affair.
Yeah. Absolutely.
Looks if hence the appointment letters were detained under the custody of Divisional Office Srirang Patter Inquiry. During preliminary inquiry, it came to light that one Shushanko Das Nolbari mobile number even involved in mastermind in the racket. And this mastermind has been released by the Honorable Court. So considering this fact, Lordship, my allegation is Lordship, I have taken 50,000 rupees. This Shushanko Das main accused has been released, Lordship. And Honorable Court has recorded
money from people, you know, with a false promise of manipulating public recruitment.
It's an allegation. Lordship.
Very, very serious matter.
No,
allegations are very, very serious.
The allegation is
In a
serious.
country where crores are unemployed, it's a very serious matter.
Look,
Zero
I
tolerance
I
for this
understand.
kind of things. So it is an allegation, of course, he's presumed to be
Allegation,
innocent,
Lordship. It is
but
not
we
a-
must see the absolutely latest stage of investigation
And
and
petitioner-
consider all the factors. He may be an alleged mastermind, but he's also alleged to be a co-conspirator, you know, part mastermind. And there can be different views on this matter. Anyway, I'm not saying that
I understand. Lordship.
I will reject, but I'm not saying that. But the thing is that we'll take a view, but we need a little more material. Updated. Updated case that.
Case that is there.
So
Lordship.
kindly check if it is available, we'll take it up in a second. Right? We'll take it up in a second.
I'm seeking a bail matter, BA matter. The person is behind the bus matter in a very civil nature matter. The wife had a shop in the Fancy Bazaar area, matter. And according to an agreement for shop in question and general power of attorney are executed on way back on 27/12/24, matter. Well, since then, matter, then FIR was lodged on 18/6/25.
Can you see that? Huh?
Yes, ma'am. Page 17, your lordship. The translated version, madam. It starts from page 17. I have the honor to inform you that the above named accused person, the owner of the shop Trade House at SRCB Road, had agreed to sell me a room measuring 80 square feet. That is Sumi Sarkar is the owner, madam, for a sum of 35 lakh. Accordingly, on 27/12, I prepared a deed of agreement for sale of shop at the general power of attorney with the accused person, that is Sumi Sarkar. Thereafter, I handed over a total sum of rupees 28 lakh to the accused person against Sumi Sarkar and said that I would pay the remaining amount on the date of executing the final sale deed. After 20 days, when I asked the accused person to come and execute the final sale deed, the accused person said that she doesn't want to sell the shop, that she will be returning in the money which I have paid. After that, when I demanded back the money, the accused person has not returned me the money for several days and has misappropriated the same. In that regard, I am informing before the Fancy Bazaar police outfit. Today, that is 18/6/25, the husband of the accused Subroto Duty Sarkar handed over the Xerox money. I am that, my lord, before your lordship. I handed over a Xerox money receipt to me, wherein it is stated that out of the 28 lakh, which I have paid to the purpose of buying the appropriate shop, I have received back 22 lakh. The same Xerox money receipt also contains my signature. However, the same money receipt contains the signature of Subroto Duty Sarkar, but not the signature of accused Sumi Sarkar, nor there are any details. It is noteworthy that the money receipt does not contain the date on which the money receipt was given. On that day, I did not meet Subroto Duty Sarkar. However, Subroto Duty Sarkar, by showing this money receipt, intends to prove that he had already returned the money which I had earlier paid, and the signature of the money receipt is not mine. That the same document is completely a forged one and it contains the seal of the government of Assam. It contains the signature of Ms. Jyoti, the notary of government, Assam. Upon asking Subroto for the original money receipt, he has said that he had got the original money receipt. Description of the shop, one RCC is in the section. So my lord, my contention is that, my lord, I am the husband of the person who owns the property. And in the meantime, that lady has been granted 3 years bail by the learned editions. So it's the order I could now lay my hands, my lord.
Does it claim to have received 22 lakhs?
No, that is the disputed factor. Even if it is 28, my lord, is the consideration price. We are asking you bring the sale deed and all, we are ready to execute. If not, then we'll refund it. So that is the person who is the
But
lady,
the allegation is that
lady, my lord.
that she was given a money receipt which she claims to be,
No, that's the photo state, my lord. That is the thing, my lord.
and that shown that she has received the money. That's why this question is very important. That if she has not indeed
The
received the
lady
money.
is not before your lordship,
Yes.
my lord. Lady was already granted admissibility bail by the trial court, my lord. Now we are under 459 earlier, my lord. So we have come for the bail of the husband, my lord, who has been
Name, what is his name?
Subroto, my lord. Subroto Jyoti Sarkar, my lord.
Is there you be necessary? But
Otherwise, it's a purely civil dispute, my lord.
No,
Emanating from a.
it has
Why?
civil dimension.
Sure.
But depending on this aspect, that's why I asked this question,
Sure.
whether she has indeed received or not. If she has not, and she claims to have a allegedly false document, then
Maybe.
it might have a criminal dimension also.
Sure.
Petitioner heard not senior counsel Z. Let's say the case that give you a short date. Call for the case diary of Anvaza Police Station. Case number 211 of 2005. That's why.
211 or 25, my lord. Conversion.
211 or 411?
211, my lord.
Okay. Third additional report. It's on 15 or 17?
My lord, as your lord.
79.
70, my lord.
17.
My lord.
Page 10, on 10/8/2024, an FIR was lodged by the informant, Noor Jahan. This is the contents. With due respect, I state that the accused is a married man and the father of 3 children. The accused started a rough relation with me by falsely stating that he is unmarried. He had sexual intercourse with me multiple times on 26.
With regard to IAY schemes. That's the allegation in housing. And if your lordship sees the allegation against the present petitioner, then your lordship may turn to the forwarding report, page number 17, para number 3. My lord, I put a question to myself, is it entail an custody after 7 years?
Branch manager. He was a branch manager.
Yes, my lord. And this allegation is that not that he has manipulated. Allegation is he should have been more diligent, he would have been more carefully scrutinizing the check which was signed by a BD. Not even a single day police remand is sought. They are directly forwarded to judicial custody.
The forwarding report says that he was in conspiracy with other accusers.
My lord, those are standard words which they use, my lord. My lord, we kindly see page 16, the initial, the first para of the forwarding report. Not even a single day police remand. And one of the co-accused is on interim bail by the learned court below. Considering the stale nature of the allegation, considering the age of that petitioner who was also 60, more than 71 years of age. It is an interim bail. Not even a single day police remand, 7 years old allegation. A man who retired in the year 2018 is being arrested in the year 2025. 30,001 local share is the last.
What of it?
Yes, you will submit. I would like to point out, although one case in the instrument of 18, but the materials now available for the investigating agency. So the present petitioner is the branch manager. So those sets and xerox copy of those sets, how my lord, whether my lord during, I would like to point out last line. The branch manager. says-
Last line of what?
last line of page 17, my lord, page 17, paragraph 3, my lord, legal question.
There's 17,
Yes.
para 2, last time.
Yes, radar W 1, 2, 3, 4, 5, 6, 7, 8. Radar the branch manager.
Yeah, I've seen this.
Jogesh Chandra Boiso with criminal conspiracy accompanied with some other accused persons with verified influencer paid the amount from government fund, knowing the bearer checks were to be forged. Accordingly, he has been arrested in connection with the case, sufficient evidence against his involvement. So the case. Next line, my lord. During investigation of the case, it has come to light that the seized forged bearer check number so and so paid by the central, so this is by the. So now here the Central Bank of India said transfer came to light that the seized post bureau check against 25,000 paid by the Central Bank of India. Delivery branch company has been appeared to be the copy of the original leaf of bureau check, copy of the original leaf of the bureau check. Bank issued to this user and the bond. So when being a branch manager, you will have to release that money from a government fund. So it's like more careful, not only one single sector, 1, 2, 3, 4 sects.
As he has rightly said, carelessness per se may not make out a criminal offense. Absolutely. But if there is deeper involvement, then
Yes.
Because it seems like.
7 years back, stale allegation, why did they, had that been, have they acted with promptitude, my lord? Then, my lord, I was in duty, I would have given them my statement. You can't arrest a 70-year-old man after 7 years of retirement on the basis of an allegation of 2018. Whatever the police does, they have to, my lord, there has to be some sanctity into the process.
heard was taken the court through the Azahar. He submitted that the allegations pertain to 2000 to events of 2018, but the case has been registered now, and the petitioner, the accused was. But I'm sorry to interrupt, but more than 70 years has been arrested and presently in judicial custody. But he brought up learned additional people who have submitted and drawn my attention to some certain parts of the forwarding report and submits that they are materials to indicate the involvement of the present accused as well. Nevertheless, call for the case diary from the concerned police station. 6 on 17 will be okay. 17 9.
17,
Otherwise, more is holiday. 17, 19, 15, 17, 9.
my lord, you are-
This thing, take.
yeah, because already I have given a requisition to be tagged. Otherwise also this will be tagged.
What's that? It's part of the. I think it has been tagged.
Yeah, we see.
Additional.
Or tag, or if you don't take, then I'll take my copy. My lord, your lordship has said that it has been, the case has been registered now. In fact, the case was registered in 18.
Oh.
They arrested. It's 2018.
Not registered now. Call for the case diary of CID PS case number 28 of 2008. Under 120P 409. Time is important, not of to agree with you. Yes.
Filed against update 5 on 2016. Where is the 2016 and this lady? Petitioner was arrested on 24/7/2025. Case 10 is a FIR. Wherein there is certain allegations that been made that she has misappropriated banks money. 409 120B 262 G sections were leveled against her and
Yes.
till today, 49 days she is behind the bar. And FIR is of 16 weeks.
We have called for the case diary with bail application of FOI case. But I don't remember the date.
Yes, so
Babul,
We can fix it on the same. Finally,
Main activity to present.
that is disposed of. Right.
But their main allegation is against these two persons. Regarding that person, these two accused person actually, he was the servant of the.
Yeah, I remember.
So they are the main accused person. So Sumita sends this.
Page 13.
All separately.
I remember. We have to get the case diary again. And children, learned companies and children, learned counsel for the accused. The present accused was stated to have been arrested on 24/7/2025. Per the border protection. Call for the case diary of CID PS case number 1 of 2016 under section 12. Which date you propose? Which stop of the year? Seventeen. 17.
Regular bail lodging, will find a FIR on page 9 lodging. Okay, unfortunately, student lodging, page 9 is there.
Provision has been.
It has been lodging under 75, 1, 2, and 3 lodging, that in maximum 3 years. Okay, second, the last line of the event says that I have tried to contact my place owner's wife, Miss Pointer Seke. I text her, she denied to agree the whole issue, lottery. And the main resultant lottery will kindly see page 4, paragraph 5 of it. There was a dispute lottery, she was misappropriating the money lottery, and for that, she was fired from the job, and after 2 days of that incident, she had lost the FIR.
And he got arrested.
Law. And he lottery called a local person lottery at any point of time, he made
Don't know when. Jalupari case. So let's get it on Monday. Let's get it on Monday.
lodging.
We need learned counsel. Smooth learned counsel for the additional. Fail the dated 5/9/2025. The accused is stated to have been arrested on 5/9/2025. Call for the case diary of Jalupari PS case number 381 of 25.
15 lodging.
15/9.
Much obliged, your lodging, much.
Lordship, take the date application. Here, absolutely violation of Article 22 of the Constitution. Lordship may peruse page 14, Lordship, the affair, page 14 is the affair, and the which entail itself that no case has been made out, Lordship. May I read the contents, Lordship?
Right, please.
Yes, with reference to the above mentioned subject general ID number so and so respectively submit following your kind information and necessary legal action. On the night of so and so, as I assigned emergency night duty from 10 to so and so, while on routine patrolling duty, so and so, vehicle along with staff approximately 30 AM on so and so, reached Pandu Temple Third area under jurisdiction. The said location we found 4 individuals luring stray dogs using biscuits in the light of multiple recent report of dog theft, napping in the Matika and surrounding area. The individuals were detained on the spot for questioning. They were along with their vehicles belong to registration to so and so brought Jalpuri police station. Further interrogation upon questioning individuals are they were during jobs with intent to capture and sell them. With intent to capture and sell them. A subsequent search of their vehicle revealed multiple snacks and large quantity of biscuits suspected to be used in the process of luring and kidnapping the animals. It is relevant to mention here that there have been a series of dog theft and kidnapping incidents in Maligaon and surrounding areas in recent times. The stolen dogs are suspected to have been transported to Nagaland, Meghalaya, where they are stored for consumption and other legal purpose. And Lordship, below down page 15, the Lordship would be pleased to see these are the 4 persons. They have been arrested on the spot. Now, these petitioners before your Lordship, they were not there during that night. No, my Lordship, they were there, their place residence. They have been arrested by the police from their residence itself from Karbi Anglong Lordship. So, in implicating them in the instant case and forwarded them. So that is absolutely Lordship violation of the, and even no notice under required. I have detailed all the things. And moreover, Lordship, the
Provisions
section.
of theft has been given. Theft.
No, nothing has been recovered, Lordship. The case of the
provisions can be
prosecution is that, Lordship.
Huh?
Major theft.
Theft.
Lordship, here, Lordship, the sections which has been, the offense which are involved in this case, the Lordship, 109. 109 is not at all, Lordship, attracted.
109.
109, that has to, 109 has to read in context of 102 of variances, which tells this murder. It's nowhere in the affair, Lordship, absolutely. I have stated in my, Lordship would be pleased to see my statement and para 5 of my petition, Lordship. At page 5, the petitioner most respectfully submit the provision of section 109 of Bharatiya so not applicable in the present context, as section 109 read as follows: whoever does any act such intention, knowledge under the such circumstance that he
Attempt to murder.
yes, Lordship, absolutely case, and this has to read in context of 102, Lordship. That is commission of murder. So
Some
no
kind of animal
applicability.
cruelty sections. They come
Even Lordship, assuming cruelty, but the affair,
that those sections have not been given.
yes,
And
that's
another thing is that an interesting question comes, that in case of stray dogs, who's the owner?
who's the one? Absolutely,
So,
Lordship.
Track.
No, notice,
Taken out of
Lordship.
the, out of their. Yeah.
Absolutely no case, Lordship. Absolutely violation of.
But he so learned counsel for the accused, the 3 accused persons seeking bail here. Namely, so and so and so. They were stated to have been arrested on 4/9/25 in connection with Jalukbari PS case number 379 of 25. In the section. So. What is 62? 62. I can have to memorize. No, it's attempt. Now it's being brought into the general provisions. 112.
Mere participants.
petty organized crime. Organized crime. The and so and so section. The allegation the Azahar dated 4/9/2025 is that during emergency night duty on 3/9/2025, the informant found 4 individuals luring stray dogs with biscuits. And upon subsequent inquiry, was found that it was found that these persons were allegedly luring dogs with the intention to capture and sell them from other states. I've perused the contents of the penal provisions given at this stage. Section 112 pertains to the new offense of petty organized crime incorporated in PNS. But P. Botaku learned additional. All for the case diary of Jalupari PS case number 379 of 2025. So it's while it's true that the state of investigation, the police official is the master of the situation, but arrest is not an essential aspect of investigation. It's the core goal of investigation is effective collecting of the evidence and collection of materials to find the truth of the matter. The purpose of arrest is only to facilitate investigation and should be resorted to only when it is necessary, really necessary for the investigation, and without which the investigation would be adversely affected. The arrest should never be an automatic step of an investigation, unless there is some special law to the contrary. Honorable Supreme Court and various decisions have tried to has laid down various principles to ensure that unnecessary arrests are avoided. Next paragraph. In the given situation, though the investigating officer has liberty and flexibility to carry out the investigation as deemed necessary by him. However, the facts and circumstances that emerges from the existing materials, I'm of the considered view that perhaps the investigating officer would have avoided arrest immediately and proceeded with the investigation and taken a decision on the question of arrest pursuant to some investigation. Therefore, while the case diary should be perused, I am of the considered view that the under trial detention of the accused persons should be put on hold for the moment. In such view of the matter, it is directed that in the interim, the accused persons, namely so and so, are allowed to go on bail of rupees 15,000 each, with a severity of the like amount each, the satisfaction of the concerned learned court, subject to the conditions that they shall render cooperation to the investigation and make themselves available for recording the statements, if not already recorded. So, this is the matter on It's on 22nd. 22nd. Then you
Highly
go-
organized,
then you
highly,
go-
organized, highly.
should arrest people at the drop of the hat.
So this is a case, my lord, how the petitioner, my lord, lied under Article 22 and 221 have been violated. But in this case, the right, with fact, my lord, petitioner is a government employee. My lord, on 8/6/2025, his mother died, my lord. And my petitioner's mother, my lord. And whatever, my lord, petitioner father is a mentally abnormal person in the family. He has to look after by someone in his family. But then, my lord, on 8/7/2025, my lord, the a day night ritual was organized, my lord, to mark the, my lord, monthly day, monthly death day, my lord. And on the very next day, my lord, 9/7/2025, my lord, the deceased wife of the petitioner, my lord, in the evening went out with her friend, my lord. And at night, my lord, he returned to home, my lord, with her friend, my lord, and made a party, my lord, to organize a party.
If you don't mind, can we see the FIR?
My lord, FIR
Those, let us start there.
is not,
Otherwise, I'm slightly,
yes,
I'm not able to pick up the story. fully. Okay, it is the SR dated 11/7.
11/7, but it was registered on, my lord, 14/7/2025.
Okay,
But my lord,
few days later.
my lord, but my lord, kindly see at before reading the FIR, my lord, page 23, my lord, seizure list. Page 23. Seizure list, my lord. Jalukbari OP GD number 173, dated 10/7/2025. My lord. The seizure list, my lord, one medicine box containing so. And page 22, my lord, the same MR was quoted before the quote below, my lord, on 24/7. Page 22, my lord. (24/7), the same was placed.
So now, the informant is the brother.
Brother of my wife.
Can we read?
Well, now, my lord, and this is the translated version, my lord. Regarding the suspicious death of my sister, Daisy Das. Respectfully, I would like to state that my younger sister, Daisy Das, was married to Sri Dipu Chandra Das, son of Sri Swanso, a resident of Pandu Sadapur in February 2023. In the absence of our parents, I and my married sister Purobi Das made all arrangements for our younger sister Daisy Das' wedding. My sister husband Sri Dipu Das is an employee of Railway Department. However, a few days after the marriage, we learned that her husband is an alcoholic and spent a large portion of his salary on alcohol. When his salary runs out, he starts physically and mentally abusing my sister, Daisy Das, and demanding money from her. My sister endured this abuse for some time for sake of saving her marriage. But when the abuse became unbearable for her, she would occasionally come to my house and stay for a few days, and her husband would then repeatedly promise not to abuse her again and take her back to her in-laws' house. However, the abuse continued. On last 9/7/2025, her husband and her husband's married sister Hiya Das and brother Surajit Das had a feud with my sister Daisy Das, and physically and mentally tortured her. And next day, on 10/7/2025, at around 5:30 a.m., my sister's husband's brother Surajit Das informed me by phone call that my sister Daisy Das had committed suicide and that we should come there immediately. I, along with my family and relatives, went to her in-laws' house, and in a room next to their bedroom, I saw my sister hanging from a ceiling fan, and I also saw her husband sleeping in their bedroom. In the meantime, the police had already arrived at the scene and started investigation. Therefore, we suspect that my sister was murdered and her body was hanged from ceiling fan to make it appear to a suicide to cover up their crime. It is said that I delayed in filing this report because I was busy with my sister's postmortem and final argument. Therefore, I can So, my lord, this FIR, my lord, is a printed copy, my lord, dated 11, page 19, kindly see.
They have come. So your worship kindly say the FIR is paying 1.5. And this petitioner, he resides in Dimapur, it's only my idol, man. Only he came one day prior to the Eid, my lord. And,
This person is,
nine person already arrested, he also already released on bail. Gulal. Already he was arrested. And other people also came because some of the villagers, man. But your worship, around 50, 60 people, it is there, man. There. Over here. So those people, some of them come, they say that we are not there at all. I don't say what the TS go after people are senior. This person, he is ready to go, my lord. He is ready to appear. Because in that case, he was somebody told about him that he is a dark peddler. And the police, had there been a police at all, my lord, people would not have done this, all these things, man. They also, my lord, did not, my lord, they concealed their identity. That's why everything happened, man. You know, so far, this person is, he did not do anything, man. Villagers have done something saying that, suspecting that this Bakait has come and that,
This person.
yes, yes.
no, this person is, that's why I said, is he related or something to?
Yes.
But yes, but he is there, but he did not do anything in this
He's
case.
not named it as a, is he?
Yes, yes. I'm
His
not-
name?
Name in the body, my name is there. I was apprehended. And I was taken by the villagers.
Oh, I see.
This is the allegation of this.
Oh, no.
I have not done anything.
Huh?
Who was apprehended by police and thereafter take out from the present.
So other person,
He was detained.
Yes.
other person had taken.
So he is the person by taking the police person. He was taken.
No. I have not attacked, madam. From the language of the FIR. I was, madam, detained. Thereafter, madam, villagers came. You are not kindly see the FIR, madam. I have not done anything, madam. I was apprehended. I was.
But learned senior counsel. In charge of, also whatever an additional prosecutor. In this application of the 482 DNSS, the petitioner without seeking PRS bail in connection with Uttarakhand PS case number 143 of 2024. In the section. The allegations in the Azahar dated 10/6/2025. On that day, following an information, police 3 women / criminals apprehended the present petition, and on the basis of the statement, one police party went on a search operation. Dash semicolon, but in the meantime, some 50-60 persons equipped with weapons attacked the police premises and took away the present petitioner, who was detained there. Learned senior counsel submits drawn attention to order dated
Yes. Last night was
13/8/2025. Passed in AP 1424/25, whereby eight petitioners stated to be villagers allegedly involved in the said attack to be granted and distributary bail, the perusal of indictment. He submitted that though the petitioner hearing is named in Daza, but he was detained by the police, and some villagers allegedly attacked the police station to take him away. And that he does not have any role in this. And it is submitted that he desires to cooperate with the investigation. Third, learned additional important. Call for the case diary of Dr. Gandhi case number so and so. However, in the interim, in the event of arrest of the petitioner in connection with this case, he may be allowed to go on bail of rupees 20,000 once year the like and satisfaction of arrest, subject to the conditions that he shall cooperate with the process of law and investigation. Semicolon, shall appear before the IO and make itself available for examination
Within 10 days.
within 10 days. List the matter on these 23. 23 now.
It can be possible in the code.
May I please? Well, this is a pre-arrest bail application, Madam. The petitioner, Madam, he has been recently elected by the member of the Jila Porishad, Madam. That is the page 25 is the appointment letter. And one
Member of Jila Porishad.
yes, recently elected, Madam. Now, what happened, Madam, there's a dispute regarding the two group of person regarding a purchase of land, Madam, and the cultivation therein. That the, what you could find the page 15 is the FIR, Madam. From 1 to 16, Madam, FIR, they are the person, they are involved in the informant, they are the accused, Madam, who went neighbors, Madam. They went to for the plowing of that particular land, Madam.
Plowing.
Yes, Madam. So, my lord, there is a dispute between the two parties. And accordingly, my lord, they were sent back. So they reported the incident to me, my lord, as a member. Then I say, you take the legal action. Then again, next day, they again went to the same with a tractor, my lord. Then again, there is some dispute arisen. And during that period, one person succumbed to the injuries, my lord.
They were
Clash. I was not in the never been in the place, my lord. Admittedly, Lordship will see the allegation is that the accused, they just went to inform me about the incident, and the vernacular is more clear. Lordship can also have the
You want to
vernacular.
read it?
Page 22, my lord. There are 22 persons named in the FIR, and my name appears in the
17.
17
You can read it.
vernacular, right?
You can read.
Yes.
Or
Yeah.
your, then you can read.
The এজাহাৰকাৰী সন্মানপূৰ্বক নিবেদন এই যে কিছুদিন পূৰ্বৰে পৰা 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 আৰু 14 নং আসামীৰ পৰিয়ালৰ লগত এজাহাৰকাৰীৰ পৰিয়ালৰ পূৰ্বতে মাটি কিনি লোৱা 1 বিঘা 2 কঠা 13 লেচা মাটিক লৈ বিবাদ চলি আছে। যোৱা 16/8/25 তাৰিখে 15 জন আসামীৰ লগত 15 নম্বৰ আসামী এজাহাৰকাৰী পৰিয়ালৰ লগত দখলত থকা মাটি বলপূৰ্বকভাৱে বেদখল কৰাৰ উদ্দেশ্যে ট্ৰেক্টৰ লগাই হাল মাৰিব যোৱাত এজাহাৰকাৰী ককাই শহীদুল ইছলামে ওচৰ চুবুৰীয়া মানুহ লৈ বাধা দি হাল মৰা বন্ধ কৰিছিল, যাৰ ফলত উভয় পক্ষৰ মাজত তৰ্ক বিতৰ্ক হৈছিল। উক্ত আঠেজৰ বশৱৰ্তী হৈ আসামীকেইজনে এজাহাৰকাৰী আৰু এজাহাৰকাৰী পৰিয়ালৰ লোকক প্ৰাণেৰে হত্যা কৰিব বুলি ভাবুকি দিছিল। উক্ত ঘটনাৰ পিছত উক্ত ঘটনাৰ বিষয়ে আসামীজনে 16-17 নং আসামীৰ লগত আলোচনা কৰে গোপন বৈঠকত। বাকী 18 আৰু 24 নম্বৰ আসামীক মাতি এজাহাৰকাৰী আৰু পৰিয়ালৰ লোকক হত্যা আৰু ষড়যন্ত্ৰমূলকভাৱে পৰিকল্পনা ৰচনা কৰিছিল। 16 আৰু 17 নং আসামীৰ হুকুম মতে 15 নং আসামীয়ে 17 ইমান তাৰিখে ৰাতিপুৱা 9 মান বজাত পুনৰ উক্ত মাটিত ট্ৰেক্টৰ লৈ হাল মাৰিব যায়। That is the only allegation that we have instructed them to go again to body plan. At the instead of 17 and 18, they again went on the next day. এতিয়া এজাহাৰকাৰী ককাই শহীদুল ইছলামৰ লগত থকা দুজন ক্ৰমে তৈয়ব আলী আৰু শ্বাহজাহান বাদশ্বাহে মানা বাধা কৰাত 15 জন আসামীয়ে হাতত দা লাঠি বেগাৰ কুঠাৰ আদিৰে প্ৰাণে হত্যা কৰাৰ উদ্দেশ্যে এজাহাৰকাৰী ককায়েক আৰু বাকী দুইজন আক্ৰমণ কৰে। উক্ত ঘটনাত এজাহাৰকাৰী ককায়েক শহীদুল ইছলাম ঘটনাস্থলীত মৃত্যু হয়। তৈয়ব আলী আৰু দুজন জখম হোৱা ব্যক্তিক উন্নত চিকিৎসাৰ বাবে গুৱাহাটীলৈ প্ৰেৰণ কৰা হয়। মৃত ছাইদুল ইছলামক মাটিত পেলাই ইয়াছিন আলী ইলিয়াছ আলী পিতল মস্তিষ্কেৰে বেগাৰেৰে দুই ভৰিৰ মূল শিৰা কাটি দিয়ে। ইব্ৰাহিম আলীয়ে কুঠাৰ ঘাপ দি মাৰি দুইফাল কৰি দিয়ে। ইয়াছিন আলীয়ে ডেগাৰেদি ঘপিয়াই হাত কাটি দিয়ে। বাকী 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 14 আৰু 15 নং আসামীজনে উক্ত ইয়াছিন আলীয়ে ইয়ালচিয়ান লগত সহযোগ কৰি হাতত দা লাঠি লৈ এজাহাৰকাৰী ককায়েক শহীদুল ইছলামক হত্যা কৰাত সহায় কৰিছিল। উক্ত আসামীজনে অৰ্থাৎ 1ৰ পৰা 15 লৈকে তৈয়ব আলী আৰু শ্বাহজাহান বাদশ্বাহক প্ৰাণে মৰা হত্যা উদ্দেশ্য হাতত লৈ বেগাৰ আদি লৈ তৈয়ব আলীৰ ডিঙিত আৰু হাতত জখম কৰে। শ্বাহজাহান বাদশ্বাহক বেগাৰেৰে হানি খোৱাৰ চেষ্টা কৰে যদিও দৌৰি গৈ এজাহাৰকাৰী ঘৰত সোমাই প্ৰাণ ৰক্ষা কৰে। উক্ত 11 নং উক্ত সংগতি 17 নম্বৰ ঘৰত আশ্ৰয় লৈছিল বুলি মই পৰস্পৰে জানিব পাৰিছোঁ। So that's the allegation, my lord. Apparently, as a member, my lord, they came to me first day. I have suggested to take the legal action. Next day, they went again to plow in the same plot of land. Fight. There's a mutual fight between the parties. One party died. I have never been in the part. They have admitted that I have never been. Only that their allegation is I have asked them to go for plowing in the place.
In their
Alleged fight is horrible.
as per the direction of the present system, I would like to point out from the vernacular itself, how this accused persons. So, ঘটনাৰ উক্ত আসামীগণে 16 নং আৰু 17 নং আসামীৰ লগত 17
Conspiracy.
নম্বৰ এইটো প্ৰেৰণ কৰিছিল। আসামীৰ লগত আলোচনা কৰি গোপন বৈঠকত বাকী 18 নম্বৰ পৰা 24 নং আসামীক মাতি এজাহাৰকাৰী পৰিয়ালৰ লোকক হত্যা কৰাৰ ষড়যন্ত্ৰমূলকভাৱে পৰিকল্পনা ৰচনা কৰিছিল আৰু উক্ত 16 আৰু 17 নং আসামীৰ হুকুম মতে not only they conspired as per the direction of the 16 নম্বৰ আৰু 17 নম্বৰ আসামীৰ হুকুম মতে উক্ত 1 নম্বৰ পৰা 15 নং আসামীয়ে যোৱা 17/8/2025 তাৰিখ ৰাতিপুৱা 9মান বজাত পুনৰ উক্ত মাটিত ট্ৰেক্টৰ লৈ হাল মাৰিব যায়। তেতিয়া এজাহাৰকাৰীৰ ককাই ছাইদুল ইছলাম আৰু লগত থকা দুজন ক্ৰমে তৈয়ব আলী আৰু শ্বাহজাহান বাদশ্বাহে মানা বাধা কৰাত উক্ত 15 জন আসামী হাতত দা লাঠি ডেগাৰ কুঠাৰ লাঠি আদিৰে
I have read it, my lord.
Thereafter, this is important. প্ৰাণে হত্যা কৰাৰ উদ্দেশ্যে এজাহাৰকাৰীৰ ককায়েক আৰু বাকী দুজন লোককো আক্ৰমণ কৰে। Then you will see how they উক্ত ঘটনাত এজাহাৰকাৰীৰ ককায়েক ছাইদুল ইছলামক ঘটনাস্থলীতে মৃত্যু হয় আৰু তৈয়ব আলী গুৰুতৰ জখম হোৱা হেতুকে উন্নত চিকিৎসাৰ বাবে গুৱাহাটীলৈ প্ৰেৰণ কৰা হয়। উক্ত মৃত ছাইদুল ইছলামক, this is very important, উক্ত মৃত ছাইদুল ইছলামক মাটিত পেলাই ইয়াছিন আলী আৰু ইলিয়াছ আলীয়ে in the presence of the accused 17
No,
আৰু
where is
ইলিয়াছ আলীয়ে পিতল মস্তিষ্কৰে
17 is not there.
Its presence in the place
No,
of
no.
occurrence is not there, but there are other allegations.
that is some of the city of other allegations.
Then I have it, but presence is not there, my lord.
Last portion you will see.
No, it's not alleged, but
And
How-
they said it is a conspiracy, the
That
secret
allegation.
conspiracy.
Well, I'd like
How they came to know about it, that the secret conspiracy.
the last portion, madam. উক্ত মৃত ছাইদুল ইছলামক মাটিত পেলাই ইয়াছিন আলী আৰু ইলিয়াছ আলীয়ে পিতল মস্তিষ্কৰে ডেগাৰেৰে দুই ভৰিৰ মূল শিৰা কাটি দিয়ে। ইব্ৰাহিম আলীয়ে কুঠাৰ দি ঘাপ মাৰি
You can read it 100 times, it will not come up my name.
ইনচান আলীয়ে ডেগাৰ দি ঘপিয়াই হাত কাটি দিয়ে।
Yes. Who?
So, my lord, how, my lord, you also may consider the gravity of the offense.
Gravity of the offense always comes at the end of the trial, not in the case.
The case is today listed only for motion. There is specific.
I know it is listed for motion, my lord.
that three persons in a criminal conspiracy.
Where from they said it's a secret conspiracy, my lord.
And whether the accused persons were present at the place or not.
No,
that
that
we
the
found
FIR
the
itself
city
said the accused
or
person, I am not
the
present.
encyclopedia of everything by
No,
the
no,
system
no,
and
no, no,
serious
no.
of
This
it.
is an elaborate FIR lodged by the informant, elaborately who and who. They have said who had, what has happened, who has indicated, who happens, who has assaulted. Everything is there, and they have admittedly said that they went to my place, and what I have suggested, go and again plow it in the place. That is the only role I have played, as per the allegation. And they said it's a secret meeting. If it is a secret meeting, how they came to know what was the going on in the secret meeting, my lord?
You are appealing for.
So, my lord, at this stage, on my prayer is that I am the government official, my lord. I am the member. I had a duty to stop it. They went to my place as a member. I have suggested to go to take the legal recourse. They went on the next day. Lordship, kindly protect me. The next day, definitely the city will come. If anything, any conspiracy comes out, definitely Lordship can reject it, my bail application. The few days interim will not fall anything, my lord. Anything will, they will lose nothing, my lord. Only few days I'll cooperate with the investigation. I am a government service. There is no flight tricks in here case, my lord. There is no flight tricks, my lord. I cannot evade, my lord, arrest, my lord. I'll rather cooperate in this investigation. This is I have also a duty, my lord. I have to perform my lord duties in this place, my lord. There are they are all the accused person. They are all the family members. How can the family members may be influenced by me? They are all family members, the witnesses.
Anyway, let me read the FIR again. I'll read it.
Where is the contents of the case that comes here?
That's senior counsel.
Then
In order for honored counsel appearing for the petition was taken to Sahar dated uh, date of 18/8/2025, in which 24 accused persons have been named, including the present petitioner. Present petitioner as case number 17.
Petition on behalf of accused when parents pending before the court. They don't 17.
What's the date on sale?
till then I am protected now. It is coming on 17th.
If the petitioner is stated to be newly elected, he is elected as
Jila Parishad member, my lord.
member of the
Jila
Jila Parishad.
Parishad, my lord.
Jila Parishad, the district of Moregaon.
Case 24 now.
There was the annex documents. In the alleged incident, one person is stated to have died, other sustained serious injuries. Pursuant to alleged land disputes. Alleged land dispute. the learned senior counsel seeks interim protection till arrival of the case there. The third, we both have put down an additional fee. To seeking the case there, further content submits that that the prosecution is opposed to the grant of interim magistrate. Learned counsel give good or appearing for the informant objects to the grant of bail and also further submits that the bail application of 208 is to 6.70. All for the case there of Buragaon PS case number 49 of 2055 on this one section, along with postmortem report and injury report. With regard to the prayer for interim bail, I once again bail the FIR and considering the nature of the allegation, the said prayer is rejected at least. List on 17/9. For bail hearing.
14 also, my lord, the pre-arrest bail application. FIR at page 11.
Different case, right?
Separate case. FIR at page 11, my lord. Attempt to, my lord.
The allegation.
The attempt to, my lord. Page 17 is the violation. Suka Astara, Dr. Murad Gopiadi.
Open diary. Since there's a allegation, let us see the case diary. Nobody's name. Senior counsel. Three petitioners, accused petitioners. Seeking bail on the 480 offenses. Or we possible on an additional. The allegation that the article 38,000. Meaning the three petitioners here is that they restrained the informant and stabbed him on his head with a sharp. All for the case diary along with medical report. Get the medical reports, that's very. Can it be on 15? Yes. List on 15. 15. Let's see.
Passport.
Done. Yeah,
There's a counseling say what about the legs also?
So.
Page 9.
Which line?
Page 9. The text of false measures.
New section, that one.
Yes,
New section.
Additional section that was by
Even the report from the concern OC was called for, whether the appellant is alive or not. That report my friend has said not his. Not so, may I pay for issue reminder and let the matter be taken up after vacation?
I'll write it down here. I forget. Reminder,
I am.
after vacation.
Very good.
58. Left clearing. Here in this case, my limited pair for a transit clear as well for limited period. On last occasion, I have submitted this argument of clear and there versus of Prana only for limited period.
It is in Mednipur, West
My
Bengal.
lord, my. Each time maybe given, but I will let you investigate.
You want final disposal?
Fine.
Because that day, no? Interim possible. I was thinking. I'm sure. First paragraph only it is clear that interim is possible, but it says the first condition. Yes. It's here. Para 93
Miles.
of Indoria is. Para 93.1, in the 93, 5 directions have been given, 4 directions. 93.1, only it has been said that notice has to be given to the PP and IO of that jurisdiction. But it will have, the court will have discretion to grant interpretation. That is there. And another thing has been said actually in this station that at least the petitioner should be reasonably satisfied the court that why he did not go to that jurisdiction. Say why not Calcutta? Because you know why that has been said? Because so as to discourage forum show. This judgment came in the backdrop of a situation where one person involved in some serious offense in Delhi came to Manipur and he got a discipline. After that, this judgment came, and that was one of the reasons for laying down this principle was, I think, that episode also. Anyway, so
this type of continuously in relation to all these cyber offenses. Because in some this type of cyber, some of the
everywhere.
step over continuously going on. This is not the so in all cases, like we have become university has rightly pointed out the discussion power so considering all the if they are till now the concerned police station has not been arrested, considering the allegation of the seriousness of the offenses, cyber offenses, they did not require any other interim protection. Let them require go and considering the offenses because in all cases.
No, this court will not go say that they appear before IO. What thing is that till they approach the Mednipur Sessions Court or Calcutta. Right.
For a period of only 15 days. Only for
No, I have come across orders of this court. And one judge must have rightly given. But it was not clear from the order whether that the first condition has been complied prior to passing of limited and super investigating officer and PP. Who are seized of the affair shall be issued notice on the first day. They are already late on the first day. Your name was not shown, so. But because if that process is continued, see, if this is not necessary, the process is very simple. You grant him protection for say 7 days, 10 days, 15 days, and ask the petitioner to approach the jurisdictional court as per his choice. Sessions or. But if notice has to be given to the IO in Mednipur and the PP in Mednipur, the particulars of which also you may not know.
My lord.
So in that will take some time. But let us, since it is explicit, let us follow them. Let us follow this. Okay, Pranam, third, learned counsel for the petitioner seeking transit anticipatory bail within the ambit of the powers under section 482 DNSS in connection with Bhavanipur PS case number 82 of 2024 under section 424 406 IPC. Full stop. It is submitted that the said police station falls in the district of West Mednipur,
My lord.
West Mednipur in the state of West Bengal. The petitioner has received a notice from the concerned police station to appear connection with the said case in which the allegation in the FIR dated help me with the date.
26/3/22. After the 26/3/22.
26/3,
My
2024. In which the informant has alleged that he has become a victim of online financial transactions. This person is your client's name,
Hafizur Rahman.
Huh?
Hafizur Rahman.
Hafizur Rahman. Is he named? He's not named, right?
Not name, not name.
It is submitted that the petitioner is not named in the FIR. Third, the Portable Learned Edition. The case of Priya Indoria versus State of Karnataka, 2024 4 SSC 749. Honorable Supreme Court has laid down the principles regarding grant of transit anticipatory bail as a special measure in certain situations to protect the liberty of the individuals. The relevant para 93 encompassing four principles laid down there and may be reproduced herein below. Expect. Thus, in a petition for such transit anticipatory bail, the court will be within its powers to grant interim protection. However, it has also been laid down that prior to passing any order, the investigating officer and public prosecutor who are seized of the affair should be issued notice. Accordingly, the petitioner side take steps. How will you collect the PP's address from the court? This is one. There should be one practical challenge. I had done one case district where it was from a very interior place of Tamil Nadu. The petitioner shall take steps for issuing notice to the learned public prosecutor and the investigating officer of the case in the same district of West Bengal. However, the event of arrest of the petitioner in connection with this case, he may be allowed to go on bail of rupees 25,000 with 1/7 of the like amount, satisfaction of the arresting authority and subject to the commission that we shall not abscond and render full cooperation to the investigation.
Otherwise, arresting authority is of kind of different state.
Different state.
So
Different state. He may not be arrested. I have thought of another scenario in dealing with one petition. Suppose somebody gets an interim, your prime objective is to get some protection till you approach. Suppose somebody gets an interim protection, suppose. Here, then after getting interim protection, the person goes to the concerned court and files a application. Application. So then this in a sense will become infraction.
otherwise, may not be territorial jurisdiction is not of this state.
Ah.
So that is some.
No, cannot. The territorial jurisdiction is important in anticipatory bail, obviously, because it can be misused. Therefore, this is an exception to the routine territorial principles pertaining to anticipatory. It's an exception. If I'm not mistaken, this judgment has been written by Justice Boyasa.
Hello.
So please have a look. These things are emerging law, they may say, but it's a very good decision. But not to be, not as a routine exercise, not as a routine exercise. Actually, that's why I said the petitioner should prima facie satisfy the person, the court, that why he is not going to the concern. It's not in another country. Why he is not going? Nowadays, one can appear to VC also. That can be also a ground. Otherwise, it will be making, it will be distorting the right territorial jurisdiction and with risk of forum shopping. So anyway.
Hello.
So how long you try? I don't know how about the notice thing you discuss. Maybe this prosecutor can help you. 2 weeks. 2 weeks.
The rest of the police station, everything is there. So now
No, police should not be a problem. Prosecutor at least. Prosecutor at least.
the police station.
Least after 2 weeks. Just a minute, take the date. Take it on 24. Try to get the notice done so that on the next day we can dispose it. But we have very limited jurisdiction.
It's an anticipatory bail application matter. Where is registered under section 64, that is rape matter, 77 voyeurism, and 351 is defamation matter. Well, the victim here, my lord, is a married lady with 3 children. In the altercation, both of us were screaming, and upon hearing our cries, my wife Asma Begum rushed to the field. When she attempted to rescue me from the hands of the accused persons number 2 and 3 kicked and punched her. As the blows landed on her head, she lost consciousness and collapsed to the ground. Witnessing her unconscious state, I began screaming loudly. Hearing my screams, my brothers Azizur Rahman, Faizur Rahman, and Ziaur Rahman, and my sister-in-law Imrana Begum came to the field to find out what had happened. At that moment, near the road in front of the house of the accused person, in front of the accused person number 1's house, the aforementioned accused person jointly charged at my brothers and sister-in-law, armed with sticks, dao, and spade, and thereby caused injuries to them. One thing which is apparent comes out from both these FIRs is that some scuffle, some altercation, some fight took place. Marbit had happened. And it is also seen that there is a land dispute going on between the parties. And the petition and this informant and the petitioners are also related by land.
Nobody has been killed.
Nobody has been killed. This FIR against us has been registered under sections 329, 1182. 1182 is the offense pertaining to causing grievous hurt by sharp weapon. Others are wrongful restraint and defamation. I don't know what they have put the
nature of injuries has not been described.
Has not been described. Now the petition, the informant in our FIR, they have already been done.
Severe injuries has been mentioned. You are right.
Now in my FIR, they have already been granted pre-arrest bail.
Here only injury. By court below.
Yes, ma'am. Their bail order is, my lord, at page session of page 30, my lord. Oh, sorry, madam, not page 30, page 27, madam. 27.
One of the petitions.
Yes, ma'am. Petitioner number 1. All brothers, Nadir, Hamid, and Subur. The nephew of the
These petitioners, it has been rejected.
yes, ma'am. This petition have been rejected. The women have been, women folk have been granted. Men, they're not basically.
What are we don't know. That's fabulous. The three accused petitioners, here in Abdul Qadir, Abdul so and so, are seeking pre-arrest bail in connection with Mura Jha PS case number 119 of 2020. The section so and so. But yes, no. What I will learn at additional thing. The Srinivas Garnet Petitioner Council submits that the context of some land dispute. FIRs being filed by both sides upon one another. In the allegation leading to the allegation in the Adahar dated 5/7/25, leading to the present case. It's alleged that there was mutual market between the parties, and that the accused persons tried to assault them with sticks, dowels, and spade, and also caused injuries to some of them. The nature of the injuries has not been described. The learned counsel has also taken the court through the FIR lodged by the side of the accused persons. By informant Abdul Qadir. The said Azhar FIR is also dated 5/7/2025 and alleges about injuries, about market and assault leading to severe injuries. Again, the detailed nature of the injuries have not been described. It appears that both the sides had preferred pre-arrest bail applications before the learned sessions of the project. And the petitioners, out of the petitioners, here it three women petitioners were granted bail, rejected for the others. With regard to the other side, it appears from the order, it is revealed from the orders dated 24/7/25. They were granted pre-arrest bail. Third, we got to learn an additional will be the same. Call for the case diary. Should we call for both the case diaries? Yes. Call for the case diary. Call for the case diary pertaining to the present case, that is Murajha PS case number 119 of 25. And also call for the case diary of it's a cross case being Murajha PS case number 120 of 2025 from the concerned police stations. I've given consideration to the prayer for interim protection till PSCD is used. Both sides have made allegations against one another. And some of the persons allegedly involved in the incident have already been granted bail by the learned session judge. Therefore, at least this, the petitioner's hearing can be given an opportunity to record their statements. On the case. In such view of the matter, it is directed that in the interim, the event of their arrest, in connection with this case, not to go on bail of maybe for the age. Surety of right, like a money, satisfaction of arrest. Semicolon, subject to the conditions that they shall maintain peace, abide by the law, semicolon, shall cooperate with investigation, and appear before the IO for recording their statements. Temporary all for the this storm. We should fix it after the 16, 15, 16, 9.
I'm the
Bottom.
Anticipatory bill application number section.
16, 17 also said.
No. FR is a page 12. Possible occasion to bill is applied. The lawsuit was pleased to grant bail to some of the poor. Six order is that page 18. This order is a favorite.
Accused persons are not named.
Not named. Your lordship will get the, your lordship will page 16, your lordship particular. There is specifically 4 persons were named, your lordship, more than 2.
Oh, I see. Now I will do the job. Particular is that page?
Page, your lordship, 16. Is more than,
Noren Putum,
then your lordship will find Dilip Peru, Domtian,
then
and Domtian, your lordship.
they are not named.
No. Your lordship's order.
Why
is
the
page
Peru?
18.
I've seen. This is pending or disposed of?
Pending.
It's a little- No, it's must be another date. It's 27/8. That's 27/8. Must have been, it must be fixed on another date.
Lordship
We
may,
can fix it on the same day if it is not.
lordship may direct this letter to be tagged along with this number. AB 1 itself.
6/8. Not two petitioners, no.
8
Let them also record their statements with 20,000 with 1 0. Or as much of what the additional this list this matter on. Any idea about the next step? No,
Lordship, so that date has not been fixed, Your Lordship. CD
Is it-
was not there on the.
I see. Is this petition along with AB number
1875.
2025 on? Should we give a date now? What do you suggest? Whatever. Our space is getting reduced. Perhaps 23 nine. Your good name, please. I'll record your name.
P. Khatam.
P. Khataf. Sister,
It will, Your Lordship, be after, immediately after vacation.
is it 15? Yes. 15, 16, 15.
It
CD notice. CD would be required. In custody since project 3/8 lordship, 39 days. Council issue will be important. Case diary not yet received, issue reminder. List on, this we have to get it before vacation. All this year we have to. 24/9. Little earlier. And they're getting filled up. It's 19. 22. 22/9. Okay. No. Say similar but 31, no. Huh? 31 CS.
Okay, may I pray for the scan copy lordship because it is a session tribal case lordship and the statement lordship how far as possible lordship is in favor of me lordship. Yet, two young couple lordship out of last they have elope with each other for many lordship. That revealed from the forwarding report itself. Page 14 is the forwarding report itself lordship. Or page 14 lordship you kindly interpret. There is last line lordship. That during investigation, the missing girl recovered from the possession of the arrested accused person. The statement, the victim revealed that she has love relationship with the accused person and they eloped on 13/8/2024.
What about this? When, which dates you propose? Because custody takes out, but the date flexibility is also increasing. Also. All packages. Or should I grant interim and call for this? Piece?
That will be better.
So, I think that's 22. That option can also be considered. Charge sheet is completed. We are looking at the bail, yes, it can be cancelled. That, but girl has been recovered.
Recommend, Lord, clearly from the police investigation, it says not if they were in love and they out of love, they eloped.
You can take one chance before vacation. Yes. Take one chance. It does not come back. About that option. For the moment. And we submitted by the learned prosecution that additional people, we got it. Charge sheet has been submitted. The accused is stated to be in custody since
13/8.
13/8/2020. He's 20 years.
No, boy is 20
Was 20 years.
and girl is lordship, as per the police calculation,
17
16 years, 3 months, 22.
All for the scan PCR. Ajum PS case number 334 of 2025. From the court of the concerned learned court. Which on 23rd, such case. This from 23/9/2025. For venue.
Can it be on 23?
23rd on the.
Oh, sorry.
That is all. My lord, in this case, my lord, the petitioners, my lord, are in jail, my lord, for 32, 33 days, lordship. My lord, allegation is can be see at page 12, lordship. And as I had watched at the FIR, lordship,
At page,
page 12 is the operative part, lordship.
page 12.
Yes, sir. Married lordship. That on 24/7/2025, one person named Zomo India, son of so and so Guwahati, Mizoram, appeared at Sivasthan Police Petrol Pump Post in an injured condition. He has been sent to medical immediately for treatment. Today on 25/7/2025, after preliminary medical attention, he gave a verbal statement that he had come from Sampai, Mizoram, along with his 3 friends, namely Thanga, Jua, Lunga, with intention to purchase fake currency. According to John Pia, the first reached Guwahati. They first reached Guwahati from where they were contracted our mobile phone number so and so and asked to proceed to Amoni. At Amoni, they were picked up by a white car bearing registration number so and so, which had 2 occupants in front of the seats. They were then taken to a house in a nearby village where 2 other persons were already present. Later, several more persons joined them. This joint group showed them take currency notes using a note counting machine. However, Wantuya and his companions, who were carrying 11 lakhs in cash for purpose of purchasing fake currency, refused to take the fake notes due to poor quality. At this, the opposite party assaulted them and forcibly snatched the 11 lakhs they were carrying. During this scuffle, John Pia sustained injuries and managed to escape and reported to the Sivasthan PP. His other companions fled from the scene. Now kindly page 16, lordship, the forwarding report of the section number 1. It starts from 15, lordship. Now operative part, well, ground of arrest is my lord, page 16, lordship.
Just a minute.
Okay, got it. There's 16, my lord, ground of arrest. Now kindly see the number 3. During investigation, he recovered total 20 numbers of 500 rupees suspected to be FICN tag note, that is total 10,000 packet in black color polythene from EO, which is in front of the house of arrested accused persons, lordship. House of arrested accused person. My lord, this was recovered from not my possession, lordship. In front of the house of accused person, my lord, other accused, not this petitioner number 1, lordship. Now, petitioner number, my lord, resides my lord, far away, lordship. Now, the petitioner number 1, Baharul Islam, lordship, it is in front of his house, lordship. But this petitioner number 1 was not, my lord, named in the FIR, lordship. No, here, my lord, just it is stated, witnesses stated their name, lordship. Now, my lord, the injured did not state their name, lordship. My lord, on the other hand, the petition number 1 also, my lord, the nothing was recovered. Please kindly see the same, my lord, at best 18 forwarding report of the petition number 2, lordship. He is Bahar Uddin alias He is Bahar Uddin, lordship, alias Bakkar, is it about 32 years lordship? Now, page 19 is the operative portion lordship.
I've seen.
My lord, third lordship. Same ground lordship, in front of the house of accused lordship. Not from the possession of the my lord. It should have been my lord, specific, no recovery from their possession. Merely, my lord, many people, my lord, gathered their lordship. Probably they were also their lord. That is why, my lord, some persons that they were also their lordship. That is why probably they were arrested lordship. My lord, on the other hand, my lord, 11 lakhs lordship. Where is that amount lordship? Why that amount is not, my lord, seized lordship by the IO lordship? That is not, IO is the, my lord, silent in that.
Lot of money.
On the other hand, lordship, on the other hand, the accused number 8 lordship. Accused number 8 lordship, he is a Sutradhar Das lordship. Sutradhar Das, he has been arrested he was arrested, my lord, on the same day lordship, and the learned Session Judge lordship has released him on bail lordship. Although this is not binding upon of this in this honorable court lordship,
That's okay.
a kind perusal, my lord, I am getting this order lordship. My lord, in paragraph 7, my lord, because of progress of investigation on 24th days, he was, my lord, released on bail lordship. Now, my lord, can you see, my lord, paragraph 7 lordship of this order lordship?
The order.
Learned Session Judge has co-accused has been released on bail. My lord, paragraph 7 lordship, and you see, on examination of the case diary, it appears that some progress has been made in the investigation. However, nothing specific has been surfaced so far as establishment the complicity of the accused in alleged crime. The accused has already been in custody since 26/7/2025 for nearly 4 weeks. Considering the nature of the allegations and the fact that the investigating officer has had sufficient opportunity to carry out the investigation while the accused remained in custody, further detention of the accused does not appear. Now, in our case lawsuit, 3 days police custody was done. They were thoroughly interrogated lawsuit. They were thoroughly interrogated lawsuit. In my humble submission, further custodial to my lord, the detention, custody interrogation may not be necessary lawsuit. Already progress of investigation is clear lordship. So further detention, my lord, that may be required, may not be required.
CD has been CDs. Kindly.
Why he has come, he has come.
He also.
He also-
Allegedly. But any allegation, but take currency thing is very serious matter.
Very serious.
It's a economic offense, almost bordering on terrorism. So that is why this is also listed in the NIA schedule act now. The currency has to be investigated. Please be for special court. Which statement? Our petition accused this year seeking bail is Baharuddin and Nur Zaman. Nur Zaman. Sorry. Of this. Baharul Islam has been granted bail. It's Baharul Islam.
No lawsuit. He is before lawsuit.
Also, he's
My lord, once, my lord,
Baharuddin.
Das law. He was in
Baharul Islam or Baharuddin.
My lord, I am Baharul Islam lawsuit.
No, here it's written
There
Baharuddin.
it is written as Baharuddin law.
Please, Bakkar.
Photograph is my photograph. Then your lordship was already, my lord, 33, 32 days losses in judicial custody. My lord, here before you lordship, my lord, higher court lordship. So,
Your good name, please. Your
MHM, MHM.
MH. And counsel, news. Uh, also heard he bought a good landed additional fee. Somaguri PS case number 166 of 25 under so and so section arose out of Ezahar dated 25/7/2025 lost by a police official. So the allegations are somewhat peculiar in the sense that one injured person appeared at the police station was from Mizoram, and from him it was revealed that while he was in a vehicle where other persons also boarded, he was taken to a place where 11 lakhs rupees that the said person was supposedly carrying for exchanging with fake currency was taken away from them, was offered to be exchanged with fake currency by the persons who had taken them. And on their refusal, the said amount of rupees 11 lakhs was snatched away.
11 lakhs was not fake, so originally.
And 11 lakhs within bracket, supposedly genuine currency was snatched away. The initial investigation is indicated that informant as well as the other accused persons were suspected to be involved in peddling of fake currency. The case diary has been received and placed before the court. Perused some relevant portions. The prosecution submits that some more investigation is necessary. So the present accused are in custody since 10/8/25 and 11/8/25.
And who is from 11 acres?
The alleged offenses of alleged offenses pertaining to fake currency is undoubtedly a serious matter, having a bearing on economy of the country. And also its destabilizing effect. So I find force in the contention of the prosecution upon perusing the case diary that for the moment the investigation should be allowed to progress further. Accordingly, the bail petition stands rejected at this stage, returned by the case director. Still progress for some time. Petition stands disposed of. You can take this, take back, is that.
So, sorry, my lord, item number, my lord, 52, my lord, can I withdraw, my lord? My lord, with liberty to file place one, my lord.
Is the in cause list left somewhere? Cause list. Clean cause list. Good, good.
52, my lord, orders, my lord.
Criminal petition,
My lord. With liberty, my lord, to file place one.
Lord Counsel, your good name?
As is Sikdar, my lord.
This is Sikdar. Seeks to withdraw this criminal petition. Comma. However, with a liberty to file a fresh one. There's some technical difference.
Yes, my lord, yes.
The prayer is allowed. The petition stands disposed of.
I love Mr. Substance.
That is the matters basically FIR is divided into two parts. The first part says that I have taken vehicle on the basis of an agreement below and thereafter defaulted to pay the amount. The second part says that I have sold the vehicle below, but the police has not registered any case below under the section of forgery below. But it page 16 is that. Otherwise, we come under a civil dispute. Married, my lord. And I'm already in custody for 26 days in the matter. With due respect and humble submission, I beg to state that on so and so my father's vehicle bearing license number so and so was taken by the widow mentioned accused Hemanto Rava and given it on lease to a PWD officer. For that purpose, agreement it was executed in the Honorable Court of Gwalpara, wherein it was written that the vehicle was taken for 6 months on a monthly lease payment of rupees 15,000. However, till date, full monthly lease amount due to my father has not been paid. Yesterday, I came to know that the accused has similarly received many people taking their vehicles on lease through deception and then selling them. Subsequently, I learned that my father's state vehicle was fraudulently sold to one person named so-and-so for an amount of so-and-so and the accused misappropriated the amount. No section of forgery, I cannot sell the vehicle without their signature. This is the FIR. Forwarding report, notice under section 35 was not given to me. Forwarding report does not justify that also. Page 23 is the forwarding report. Prima facie, civil dispute. Vehicles, 7 vehicles have been recovered. We have annexed the serial list.
This vehicle has been recovered.
All the vehicles, 7 vehicles have been recovered. I was in this business. So 26 is in custody. Only further custody is not required. 60 days is the mandatory period.
Well, he is there. It is what other. The vehicle. So when this person was caught, then some other things were paid for. There were several vehicles from this statement also that were reflected. Several vehicles being covered, only led by him. And he had to have several vehicles to be recovered. This is what of we will enter into an agreement with another agreement. Then we will say that there are several places like here. From goods, position, he has sold the vehicle.
The particular informant's vehicle has been recovered.
That vehicle, that particular vehicle is not mentioned in that, but
I recovered last week.
but there are others as well. So I get to be.
Can I?
Those recovery were made and being led by.
Third in other and a question on an additional. Accused. Hemanto Rava is seeking bail in connection with Walpara police case number 159 of 25, the section. Is stated to be in custody since 16 April. The allegation in the fire dated 15/8/2025, lost by Imran Ali. In fact, the accused took on hire his father's vehicle of Hyundai make, hearing registration number A01BQ1805. Subsequently, on a lease, but the lease amount was not paid. And later he came to know that the vehicle has been sold off to another person. So it is also alleged that the accused has deceived other people also by this modus operandi. The case diary has been received. Relevant portions produced. Is submitted by the learned additional video that as many as 7 vehicles have been recovered upon information provided by and upon being showed by the accused. Is submitted by the prosecution that investigation has revealed materials indicating that the accused, a habitual offender of this kind of illegal activities, and using the same modus operandi, yes, duped many such owners of vehicles. It is also submitted that more such vehicles remain to be recovered. Materials in the case then indicate recovery of different vehicles of bearing different recovery of vehicles bearing different registration numbers. This particular one is easily there.
Recovered, case 40 Miller, we annexed the serial. 7 vehicles were recovered Miller on at my instance after my, and we were taking the vehicle for the purpose of it. We failed in the vehicle. That is the case. So by the selling of the vehicle that my learned friend is alleging, there is no allegation of fraud. I can sell a vehicle without doing that. 26 days I am already in custody. Mandatory period is 50 days.
Considering the nature of the materials revealed the case that by the investigation and the projected/imputed conduct of the accused, or projected and imputed alleged conduct of the accused, dash cannot be prudent to grant bail at this case.
There one submission was there, Miller, that's lots of need to consider. Is Miller, notice was not given to me, Miller. And they have not even justified it why notice was not given to me in the forwarding report. There is a judgment of the coordinate bench also, Miller, which says that notice is not mandatory, Miller. But it has
Down should be given.
down should be given. If you also see the forwarding report, Miller, that is not there, Miller. Forwarding report, you will also see is not page number 20. And it's page number, not, we take a page 23 minutes. That is all.
So for some these mistakes, knowingly or unknowingly.
In that background also my
Grounds.
Grounds, Miller. Not the way to them, but why notice has not been given to me, that is not there. So the coordinate bench, have been not uploaded yet. That is also my.
The learned counsel submits that the accused has not been noticed and sufficient reasons have not been given for arresting him without getting notice. There was the grounds of arrest on in the, they have followed these principles behind arrest, they followed. Those the grounds narrated in the forwarding.
Grounds are there, Miller, but why notice was not given, that has not been justified.
Checklist. to be given.
That is not. That like not also, 26 is the name of. Make conversion.
I've also perused the grounds narrated by the for seeking police remand. Nevertheless, considering the serious nature of the materials, prima facie indicating illegal activities on an organized scale, the bail petition stands rejected at this stage. Return back the case.
I'm over.
Please, Your Lordship. If I've been arrested under section 310, subclause 4 for preparation for committing the offense of dacoity. However, my lord, no recovery has been made from my end, from my body till date, and I have only been arrested on the basis of a forwarded WhatsApp video that has been found in my found on my mobile phone. My lord. And nothing else, my lord. No overt act has been recovered.
What's the new provision now? 399?
310 subclause 4, my lord. Talks about preparation, my lord.
Preparation.
Overt act. Any tangible steps taken by me to commit the offense.
Preparation.
However, no overt act has been recovered from me till date. my lord.
Okay. Okay. CD has been received. Yes.
Next year, definitely 10. It was about to be, so that would also make next month. Statement. As well as.
My lord, based on my
Ten,
Subsection 4.
The definition itself says that when 5 or more persons jointly commit or
Robbery.
attempt to commit a robbery, or when the whole number of persons who jointly committing or attempting to commit a robbery, any persons present in a incest commission or attempt, amount of 5 or more persons, every person who commit, attempting or aiding the same to commit. We're looking to the other sections, we have been something. Especially.
My lord, in this case, my lord, in this case, 310(4). 4, we have to specifically focus on section, subsection 4, my lord, which talks about whoever makes any preparation for committing dacoity. Preparation includes, my lord, overt steps, any tangible actions that I have taken to commit the offense.
Not necessarily.
What has been
towards
recovered from
offense, but it's difficult. Preparation is usually not a crime, but there are some exceptions, right?
However, my lord,
So this is one exception.
my lord, one more aspect that I would like to bring to your kind notice, my lord. I was arrested on the 17th. I was in police custody till the 21st. Post that, my lord, my case was re-forwarded to the judicial magistrate for judicial custody. Since
3
then,
days.
I'm in judicial custody.
3 days police custody. 3 days.
17 till 21st, my lord. That's it.
Okay.
So post that, since then till date, I'm in judicial custody. So that shows, my lord, even the police does not want me for custodial interrogation. My lord may enlarge me on bail and impose stringent conditions on me. You cannot impose till the time investigation is over, ma'am.
Can I have?
Since 22nd till date, I'm in judicial custody.
Used. Such moral. Additional people. Additional stated to be in custody since 1908.
Arrested on 17th, my lord.
Stated to have been arrested on 17/8/2025 and was remanded on 19/8/2025. Presently in judicial custody.
Since 22nd.
In connection with Gorshuk PS case number 245, 2025, under section 310 PNS. So. See the records. But yeah, I think.
Miller would notice that I've been arrested based on my confessions and a forwarded WhatsApp video on my mobile phone. No tangible recovery other than that.
Because that was attempt.
For the prosecution side, that is a prima facie evidence, the alleged forwarded WhatsApp video.
Actually, the evidence.
WhatsApp video is not tangible.
The allegations against the accused persons and some others named in the FIR is regarding preparation for committing dacoity. The said act is now punishable under section 310(4) BNS. Within bracket earlier 399. His diary has been received and Learned additional submits that investigation is not yet completed and incriminating materials have been found, lending support to the allegations. Any arms recovered from?
No arms, no maps, no sketch plans, no reconciles, nothing, Miller. Just on the basis of a video, Miller, on my phone. There can be numerous videos on my phone. Just on the basis of a video on my mobile phone, you have arrested me.
Video showing arms.
How does that show preparation?
Yes.
That's a forwarded WhatsApp video, Miller. Plus, how does that lead to preparation? How can you connect preparation with a video on the phone? Well, since 22 days I'm in judicial custody, this release does not require me. I can come as and when required, Millet, for investigation. Millet may impose stringent bail conditions on me. I'm a local resident of Guwahati, Millet, Gorswick. I'm not fleeing this country or this state.
This materials. So this offense. Also,
Let them show any overt acts that have been recovered, Millet. Just one simple sentence won't work serious. Prima facie. There has to be tangible acts that need to be recovered with the prosecution. They have not been able to do it till date. And one more co-accused has been released on bail, Millet. I have a copy. A co-accused has been granted bail.
submit. See the reasons.
By the sessions.
Doesn't.
Just be kind of perusal, Millet. Just a co-accused who has been released on bail by these sessions. Rahul.
So this particular section punishes criminalizes the act of preparation, but has been incorporated in the penal law from the point of view of public safety.
Which is not violated in this case.
But there has to be some materials. Preparation is in a way a little vague thing. Preparation. From what basis can we say that he was
No
preparing
connection.
for something, right?
No connections.
So,
The confessions are not admissible, Millet. That's a basic principle of law, Millet. But still.
This is a bail petition, but still not.
So how can you use that in a bail petition? But the question is, has there been any, Millet, even the stolen cash has not been recovered. Even the stolen cash has not been recovered till date.
Investigation is going still. That basis investigation starts.
Even the stolen cash has not been recovered till now. Even the cash which is being shown in the video, Millet, That cash has also not been recovered. So on what basis they're keeping me behind the bars, my lord? That's a question that arises. My lord.
What was seized? Nothing.
Seized, but mobile phone was seized, my lord. That's it, on the basis of a
Forensic,
pity.
the same for forensic.
Yes.
But for that, I don't, my lord, for that, I do not need to remain in custody in this.
Yes, sir, the involvement of the other two cases, recovered stolen property, if any also.
One of the co-accused has been granted bail.
Sir, one has been granted bail, other accused are still yet to be apprehended.
So you have taken, extracted all the information from me.
If
So
sometimes-
why do I
can
need to
update
remain
it
behind the
after
bars now?
Case diary auction. What is the stage of progress of investigation?
So till then, I should be granted interim bail, my lord.
Give us a short take.
My lord, in fact, in the nothing has been recovered, my lord. Prima facie, there's no recovery of any overt step. That's
Application
my lord.
except six. Preparation. Attempting to commit the quantities also. Two sections.
My lord, they have equated suspicion with preparation. Suspicion cannot be equated with preparation.
Sections.
The mobile phone has been sent for forensic examination.
Yes.
Right?
That has been done, my lord. Why do I need to stay behind the bars, my lord? That's my only humble plea. That's the question I'm saying.
Shorted next week. That's not a good metro person.
But I'm a local resident. I'm not being this place. My lord, may impose
Can you
stringent
do-
conditions, my lord.
There may be there are two aspects I've seen. There may be some, serious things to be investigated. And if actually eventually full materials are found, then it's a serious matter. But at the same time, this is also true that there is no recovery, and most of the incriminating materials is actually on their statements, their statements. So from that point of view, he is also correct. And in a way, you are also correct.
My lord, interim bail may be granted till the next day.
They were planning to, as per the statement, they're in a loot businessman's house. But that is their own. So to a very limited extent, it can be taken into account for bail, but not everything. Maybe you want either they can release on bail on stringent conditions, or you have to get an updated scene.
Yes.
Stringent conditions, my lord, I'm willing to,
Next week, Tuesday. or
my lord, may
Wednesday.
impose any stringent conditions on me.
What is the last endorsement? It's more or less updated actually,
Yes,
5/9.
my lord, there's nothing else, my lord.
CDR call also.
CDR would be a relevant thing,
Since it
the
has been
photographs of the, but
It has been separate,
the linkage has to be built. The linkage has to be built actually.
Which they will not be able to show, my lord. No connection built. My lord, if they are not able to build anything till date,
No,
what
that
can
you
they do?
that you cannot say so confidently because you don't know what is investigation going. This is the content
My lord,
outcome of the
my lord,
investigation.
consider
You do
the
not know.
fact that
You
I'm
feel-
in judicial
As per your
custody.
instruction, you feel that.
Speak it to your boss.
My lord, I'm in judicial custody since the last 22 days. If there is anything, I can cooperate with the investigation as and when someone.
Last word, sentence. Yes. The learned people has additional has placed the filtering form. So investigation has progressed to some extent, but it is not completed. Regarding independent witnesses, I find in the statements of seizure witnesses regarding seizure of one mobile phone, where photographs of cash were found. Apparently. Most such photograph is part of the case there. The incriminating materials revealed so far mostly in the nature of the self-incriminating statements of the accused persons. That the named accused persons hearing. Then the accused persons seeking bail hearing, along with other FIR named accused persons were making preparations to commit dacoity in the house of one businessman in that area. Nevertheless, considering the nature of the incriminating materials that are found in the case diary, despite the alleged offenses being serious in nature, I'm of the considered view that perhaps the accused persons should be allowed to go on bail at this stage, subject, however, to suitable conditions. Accordingly, the accused person allowed to go on bail 30,000 each, with a surety of the like amount each, to the satisfaction of the concerned learned court, and subject to the conditions that number one, they shall not abscond, they shall cooperate with the remaining investigation. Number three, they shall not misuse their liberty to commit any offenses, including any offenses pertaining to property or person. Next, they shall not hamper or tamper with evidence in any manner. Next, in the event of violation of any or more of the bail conditions, the prosecution shall be at liberty to move an application for cancellation of the bail. Return back to this that bail petition stands as post of right after. That is same also. Much obliged, you know. Much of 57 also. Yeah. Thank you.
Yeah, please, your lordship, my lord. Here, the petitioner was arrested on 12/12/2024. He is behind the bar for, my lord, 273 days, my lord.
This is a NDPS metro. NDPS metro.
And he is behind the bar for 273 days, my lord.
Okay.
Nothing has been recovered from the possession of the petitioner. He was basically arrested on the basis of the statement of the co-accused, which has been hit by my lord Tufan Singh case, my lord.
Tufan Singh is for trial, in my humble opinion. Trial is barred,
That's
but
my lord.
black and white, I think, subject to correction, even correct me if I'm wrong, subject that kind of say, just using that expression, a very clear black and white principle probably has not been laid down. That moment this is found to be, only on the basis of co-accused statement is entitled to bail. I may be wrong.
Yes, my lord. The lordship is correct, my lord.
But Tufan,
In respect of investigation time, that can
But
be.
but
Here in the
that
instant.
definitely that can be
Yes,
taken
madam.
into account.
Yes,
That's for sure.
yes, my lord. In the case, my lord, formal complaint has already been filed. My lord. And except this statement, my lord, nothing has been statement against me, my lord. That is important thing, my lord. Now they cannot, my lord, at the time of the ultimate jurisdiction, my lord. I shall be, my lord, really, if there is no statement, my lord, only basis of, my lord, CDR, my lord, it has been called by my cousin, my lord. Can a person be convicted, my lord? I am not on that, my lord. I'm basically, that's very risky because co-accused statement as such is a doubtful thing. Yes, madam. So on that basis, it will be very contrary to logic, yes, madam. Natural fair play. Yes, madam. Well, basically, I remember now. I remember. Yes, madam. Basically, 47 statement, 48 statement. Sorry, madam. Section 47 in respect of ground of arrest. 48, my lord. That you are taking that ground? Yes, my lord. Then first we have to see that. Yes, my lord. First, otherwise, if that is supposed want to be violated, then 37 might become academic. Yes, my lord. And my lord, next, my lord, that 50, my lord, memorandum of arrest. We'll see that. Let's. Yes, my lord. Memorandum of arrest, my lord. Should first cross that bridge. Yes, my lord. Memorandum of arrest, my lord. That has not signed by the witnesses. Can you help me with that? Yes, yes, my lord. I'm coming one by one. My lord, already submitted your lordship that 47 document was not seen by the magistrate, my lord. And if your lordship go to the record, my lord, that document has been shown at the page number 143. If the document was not taken before the magistrate, my lord, I already submitted some blank paper, took the signatures, my lord, dates, right, and my. Subsequently, my humble submission, as because it was the 47 document, my lord, was not seen by the magistrate, that cannot be taken cognizable by this court, my lord. And for this purpose, 47 document go. Now coming to the, my lord, 48 document, my lord. In respect of 48, my lord, section 48, my lord, intimation to be, my lord, to the family member, my lord. I have got the, my lord, that, my lord, document, my lord. Here, my lord, if your lordship go, my lord, 48 document is the not part of the, my lord, formal complaint, my lord. In respect of list of document, my lord, that 48 document is not available. In respect of 48 document also, my lord, it was your lordship kindly come to the, what is it? Let's see. Okay. It is in the record, my lord, I think. In your lordship kindly look, my lord, my wife name is Casey. Mafida Bibi. And if your lordship go in that document, I think there is no signature, whether it was received or not, my lord. There must be endorsement. I am submitting, I shall produce all the judgment. And my lord. And third, my submission before your lordship is that, my lord, if your lordship goes to the, my lord, if your lordship go to the, my lord, arrest memo, my lord. Yes, my lord. Page number 58 of my additional affidavit. 58 of my additional affidavit. It is on the record also, my lord. Arrest memo. Yes, my lord. Here, no signature is available, my lord, of the witnesses. Have you also got it? And in respect of intimation of arrest 48 also, my lord, as per Bihan Kumar, my lord, last finding of the Honorable Justice, my lord, Protester Singh, is that you have to communicate at the ground of arrest to the family member also. That is also not available. My humble submission before your lordship. This is, my lord, my case, my lord. Subject to correction of other side, my lord. I want to produce some judgment, my lord. No, on these contentions, let us hear the other side. Yes, madam. Thereafter, I shall show this bridge is decided the issue. In your favor, it ends there. Suppose it is not, then we'll go to 36. Yes, ma'am. Can you check the microphone? Just magistrate.
Yes, let us have nothing. involvement is going there. Involvement is there. Sufficient materials are there.
No, let us not go into that. Since you have said that this grounds of arrest, the 47, 48 notice has not been given, no, or the contents are in a, he's saying.
And also 35
When
D.
council submits that the 48 notice is not there, not there at all, not there at all.
My lord, my humble
Just
submission,
there, but
one
no witness.
intimation is there, my lord.
No,
But
no endorsement.
no endorsement, nothing is there, my lord. And my submission before your lordship is that in 48 notice also ground should be mentioned, my lord.
Yeah.
That is the law.
And 47, there's no endorsement, 48 grounds, it's not there. So let us first tackle that.
To comply, that is why it has come. It was earlier, it was called for, that was what it has come and it 47, 48. In lordship arrest number,
35 billion. 35 billion.
Case diary has been received. Oh, it's here. There's some sort of copy in this one. Your flag.
Yes, sir. Was called for all the documents, 47, 48.
Alea Bibi.
Yes,
That is the. In a situation where the notice is not supplied, given, or notices, it is, nothing is mentioned. That stands on a different footing, where some reasons have been given. Then you have to determine whether those reasons are sufficient. Notice is there. He says that there is no endorsement. In the 48 notice, there is no endorsement.
No endorsement, my lord. My working is there, my lord. Mofita will be my lord. This is. And I am coming one thing, my lord. Assuming, my lord, but not admitting the fact. Notice has been given. Where is the ground, my lord, at that notice? No ground has been.
Both the notices, whether one finds it acceptable or not, whatever, that is another matter, but only this one sentence has been written, that you have been arrested in connection with seizure of 3.9 kilogram of metam, this one, the tablet. This tablet.
My humble submission before your lordship that I was not arrested for president. That is why I am submitting.
You were
Even-
not arrested along with the prototype.
No, my lord. I was arrested after 6 months, my lord. After 2.5 months, my lord.
Based on statement of.
What is the basic facts, my lord? That is the judgment of Bihan Konpo people. You have to mention all the basic facts. Nothing is available, my lord. And my lord, my humble submission in respect of my lord 48 notice, my lord. It was I am not receiving, my lord. My name is PSA. Murpita baby, my lord. And moreover, my lord, even it is assuming, but not a meeting. Where is the ground of arrest on that notice, my lord? Lordship, kindly read that notice, my lord. And your lordship will find there is no.
Arrested in connection with seizure of 3.9 kilogram of this
Yes,
tablet.
ma'am. Yes, ma'am.
These tablets were seized from another person.
That is escapes from another person. After 2.5 months, my lord, I was arrested, put me behind the bar, my lord. And there is a judgment. I shall show your lordship. You have to mention all the basic facts
Specific to the person.
specific to the person. That's true, my lord. And in respect of 36, my lord, arrest memo, my lord, our judgment has been discussed, my lord. DK Basu has been, your lordship has already shown your lordship, paragraph 35 of the DK 5. It has to be, my lord, one witness should be present, my lord. And considering these facts, my lord, our High Court has released the person on bail, my lord. Because some constitutional safeguard has been given, my lord. If that constitutional safeguard should be, my lord, strictly followed up, my lord. If it was not followed up, my lord, then that is, my lord, constitutional right has been violated. That is why I am submitting, my lord, repeatedly that in Bihan Kumar judgment last part has said, 48, you have to be mentioned to be family member about the ground of arrest. And
I have informed my arrest to my family. I have spoke to my wife in Europe. Signature is there also.
my lord, I am taking witness, my lord. It should be endorsed by the one witness. I said, so the judgment, man. Section 36.
I will not dictate. Others will get late.
Yes, my lord.
After court hours.
I am showing some judgment, my lord.
Can submit and complete your.
Yes, my lord.
I will
Procedure of arrest,
dictate
36.
after court hours.
Yes, ma'am. Procedure of arrest. Duty officer making arrest. Every police officer, while making an arrest, shall bear an actual, visible, clear identity his name, prepare a memorandum which shall be read to one man. Have you lordship got it? 36 of Bharatiya Nagarik Suraksha Samhita. Section 36.
Yes.
BNSS, my lord.
Yes.
A is the, my lord, I am concerned about B. Prepare a memorandum of arrest which shall be attested by one witness who is a member of the family person arrested or respectable person. Member, so a member of the locality where arrest is made. If your lordship go to that document, my lord, not a witness is not available. And considering this thing, in our High Court also granted bail, my lord. I didn't know. I am coming, my lord. First, your lordship, DK Basu case, my lord.
Granted bail in a commercial quantity case.
Yes, ma'am. I have so
Because by infraction of this particular provision,
yes, ma'am.
suppose there is no witness, otherwise suppose grounds have been given.
Yes,
In that case, would it be a fatal information prevailing over statutory bar?
yes,
Here we have a
yes, ma'am.
statutory.
I shall show judgment, my lord.
Here we
Lordship,
have a statutory. bar.
yes, my lord. My lord, 35, paragraph DK Basu. I have given the judgment. Yes, some.
Yeah.
Lordship, kindly take. I have.
No, you have given it. You have given. I have. You just tell me the paragraph.
Paragraph 35.
The violation is here.
I am reading 34. Then, in addition to the statutory constitutional requirement of which we made the apparent view that it would be useful, effective, structural, appropriate, machinery, contemptuous recording, notification of all cases, arrest, detention, or to bring transparency of accountability. It is desirable that the officer arresting person should prepare a memo of arrest at the time of arrest in presence of at least one witness who may be a member of family of the arrestee or a respectable person of the located from where arrest is made. The date and time of arrest is recorded in the memo, which must also be countersigned by the arrestee. 35. 2. That the police officer carrying out arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one of the witnesses who may either be a member, family member, or arrested or respectable person of the locality where from arrest is made. It shall be countersigned by the arrestee and shall contain the date of arrest. Where is that, my lord? It is not available. And my lord, paragraph 37. The requirement referred to above flow from Article 21 and 22(1) of the Constitution and need to be strictly followed. This would apply with equal force to the government agency, also the reference has made earlier. Clearly-
Normal, I'm just repeating myself. Normal bail, it will be easy to apply this. No, the element of discretion is more in a normal bail. But this is not followed. There is infirmity in the arrest, and therefore it can be granted bail. But in a case like this, or you have
Yes, I am giving.
whether that will be an infirmity of a nature which will prevail over the statutory bar, because in Bidhan Kumar, things have been made easier for
Yes, ma'am.
implementation, because it has been clearly stated that if notice is violated, then the person will be entitled to get bail, irrespective of statutory.
My lord,
But here also there is a reference to that this flow from Article 21 and 22.
Yes, ma'am.
This, as you know too well, 37 is a, in commercial, all cases where 37 applies, 18 and then 27A and commercial quantity. Any bail granted in violation of 37 will be absolutely null and void. That has to be followed. 37 will apply. Only in case of, specifically it has been said in Bidhan Kumar that in case of violation of that, it will prevail over the statutory. Anyway,
and my lord, in Procedural case also say, it's a law under Article 141 of the Constitution of India. I am, my lord, showing one judgment, my lord. Lordship, I have one, paragraph 29. So far, this point is concerned.
oh, yeah, please. Which judgment? No, I have a look and give it back to you. No, that's why I'll think about it. This is our court judgment.
Yes, my lord.
Our court judgment.
Our good judgment. I am reading, my lord. As regard the compliance of section 36 of BNS regarding the requirement of getting memorandum attested by one witness is concerned, it appears that said provision has not been complied with in this case, and no such attestation of memorandum of arrest been made under section 36B BNSS. Further, as regard the compliance, ultimately he was released on bail.
This was 48 notice was not in place. Was not. And it is easy to decide.
And I am submitting my repeatedly.
In this case, 48 notice was not there, because they could not show 48 notice that it was given in. It has to be, relatives have to be intimated on the grounds of arrest,
Yes, madam.
which are usually the same as given to the person, and given in writing.
Yes, madam. That was not.
As it's necessary. That much is.
And that is the commercial para 3, madam.
That much is easy.
Yes, madam. And my lord, I saw judgment, some judgment of the man, in respect of not communicating. Your lordship, kindly to put a communication.
Constitutional,
Remember.
now after this, Bidhan Kumar Pukasto judgments, now we know that constitutional provisions violation stands on a higher pedestal. Higher pedestal than procedural,
Yes, madam.
hurdles,
Yes, madam.
however strong they may be.
My
So,
lord,
yeah, so in a way, this also can be interpreted from this in a way.
yes, moment, my lord, it was said in Persisting on judgment of the Constitution and Dance, my lord, that article, they are right under Article 22(5). Your lordship, not the preventive detention case. And Article 22(1) is the same. From Horsit Constitutional Bench judgment has been taken in Bidhan Kumar and Procedural case. Moment that is taken, my lord,
Communication to the detainee,
yes,
22(5).
yes, my lord. Moment they said, I am sorry, I can read my law. This is the judgment, my law, of our High Court.
Take back.
My lord, Biman Bora, bail application 1354/2025.
Okay.
That para 5, my lord. In support of submission of so and so, it's a communicating, and I am coming to finding accused purpose of giving, provided section 50 or section 14 may be noted in addition requirement 51, 2 and 3 of the second part. That has been mentioned, my lord. Then your lordship, Come, my lord. Your lordship. Para 8, my lord. Other 3 also important. I am not, my lord, taking time.
Correct, I do.
Mr. Bora, Lanak Sciences submit that information of arrest and grounds of arrest are distinct requirement. There is a distinct requirement, my lord, information of arrest and ground of arrest. Here they said simply in the notice that so and so tablet has been recovered, so and so, so you are arrested. They must mention the ground, and that is why I am submitting. I was arrested 2.5 months back, man. If I was arrested in the place, they may say into paucity of time that may be mistake. Although that is not acceptable by the decision of the. But where is the ground? Why I was arrested? They should mention all these facts, my lord. Basic fact. The what you know very well. In Bihan Kumar and probably basic facts, you should be mentioned all these things.
Specific to the person.
In the present case, when there is no communal ground of arrest petition on family member relative, there was no communication of the ground of arrest to the petitioner, family member, relative, or friend. The communication was merely intimation of arrest and devoid any mention ground. They were vitiating the arrest itself. They are only given the intimation money. If you also go to a document. Then, after the hearing on both sides, no such ground stated, issued, requirement is mandatory to the non-financial arrest 21 of the Constitution. In the Bihan Kumar mentioned, my lord, ultimately he was released on bail. Then your lordship, there is a judgment Nur Islam I have given.
Yeah.
Bail is 1757. Your lordship, kindly come to the para 3, my lord. It is a very short judgment, my lord. The sole ground challenge in the bail application submitted by that notice of the section has been served of the family member. In order to verify the scan copy of the case diary call for receipt placed before the court. Then para 8. The arrest memo is available in the case diary, but same also does not contain the signature of any witness. Any case, an arrest memo does not serve the purpose of 48 BNSS. Accordingly, he was released on bail. Then, my lord, Lalsun Marmal, another judgment, my lord, passed by this honorable court, my lord. Lalsun Hulu Mar.
It's
Page, my lord, para 5. Para 5, my lord. Page 3.
got it.
Yes, madam. The ground of arrest distinctly mentioned and the arrest, both the arrest family member were informed about the arrest. Annexed to page 29, 20, 30, 32 petition Kali ground of arrest. In addition of ground page 31, 32, annexed to the petition, section 50 of the CRPC also include ground of arrest. The ground of arrest vividly described in writing page number 31, 32. The brief vividly described in writing both the petitioner have affixed the signature in English to 22(1) to the arrest memo. Both the petitioner spouses have informed about the ground of arrest. The brief fact of the case has also distinctly described the petitioner. However, no copy relating to 40 and 50 have been annexed to the petition nor by the standing council. Does not clear from the 50 essay. If no grounds were given to the spouses of the petitioner, then mean 48. Then the petitioner desires to be released on bail. Then, my lord, para 3, my lord. The purpose of section 50A CRPC making obligatory the martial marriage inform about his arrest, friend, relative, nominated person, ensure they would be able to. I am not reading, my lord. Your lordship, kindly come to the next page, page 5, my lord. Just 4 line, my lord. Just second line. Nominated person. Therefore, the purpose of committing ground of arrest to the detained edition relative as mentioned, not a formality, but to enable the detained person to know the reason for his arrest. And last, it is violated Article 20 of the Constitution, hence the requirement of communicating the ground of arrest in a writing not only to the arrested but also friend, relative, nominated person so to make his arrest. Then, my lord, your lordship has already gone through the Pankaj Bansal case, my lord. All judgment, my lord. My humble submission before your lordship is that, my lord, in respect of Pankaj Bansal, one important thing is that, my lord, it should become from the record of the, my lord, that, my lord, case, my lord. And my humble submission, if it is not endorsed by the magistrate, I have stated, my lord, that subsequently they have taken some signature in blank paper. That cannot be considered. And this document was 173. Arrest is the first, second, third, 1 to 10, my lord. If it is 143, my lord, your lordship, that my lord. That is submission, my lord. In Pankaj Bansal, Limai, Modhu Limai case, 3 judges judgment, my lord.
Pankaj Bansal is PMLA.
No, my lord. Pankaj Bansal is that 2. On that judgment, Modhu Limai has been, my lord.
PMLA.
PML, sorry. PML. Yes, my lord.
Yeah, Madhulema.
Yes, my lord. Yes. Page 41. Paragraph 41, my lord. Pankaj Bansal, needless to say, followed all over the country that PI officer exercise power by a certain country authority to inform arrested person by furnishing in writing while other part in a very prescribed manner. Then my lord, paragraph 43, my lord. The second, I'm coming at there, man. B. Santali Balaji, man. B. Senthil Balaji. Paragraph 43, 1, 2, 3, 4, 5, 6, 7 line. And place on record, we find that page, paragraph 43, page 597. Place on we find that 6 pages, the ground of arrest recorded in the case and Pankaj Bansal person have not been produced before the court, but it is content they were produced at the time of remand. However, already noted did not serve the intended purpose. I am submitting, my lord. When he was arrested, he was given 47 or 48 notice has been communicated and other thing, my lord. That should be endorsed by the magistrate that produced that we have been complied with. You will also not find the endorsement of the magistrate. Subsequently, if you give this on jail and other thing, my lord, that will not fruitful result, my lord. I am dictating. And we will also kindly look, memorandum and arrest was endorsed. But that document was not endorsed. Remembering the arrest by the very purpose of constitutional security provision. I am, your lordship, I am coming behind Kumar, your lordship knows very well. I read only one part, my lord. Last finding, my lord, page 42, 823. And quotation signal. That judgment, my lord. There are 41 and 42, my lord. Para 40 last 3 line, my lord. Page 822. Para 41. As other person accused as may be disclosed, the nominated by the accused person for the purpose of giving such information as provided under section 58, as may be noted, this is an addition of the requirement of provided under section 51 CRPC. The purpose of inserting 58 making it obligated to the person arrested from arrest and relating nominated person. I am coming, my lord, from therefore. Therefore, the purpose of communicating ground of arrest to the detainee in addition to the relative as mentioned is not merely a format but enable to detain person no friend relative constitution. Hence, the requirement of communicating ground of arrest in writing not only to the arrested person but also friend, relative or suspect must be disclosed, nominated by the so make to mandate Article 21 of the Constitution meaningful. That you have to inform ground of arrest to the my lord, family members. And as per I verified the record, I have not found the ground of arrest has been communicated to the relative or family member. And I want to show one important thing, my lord. If you also go to the page 15 of the petition, my lord,
Page 15.
yes, my lord. You will also see the forwarding report. Annex 2, page 15, 1 5.
One five is
1 5, my lord, page number. Annex 2. What's the enclosed document? When you have
yes.
arrest memo, medical certificate, Joma Talasi memo. Where is that 47, 48? That itself so. At the time of arrest, it was not given, my lord. And my lord, your lordship has read, my lord, many times, my lord. And my lord, I am so one thing, my lord. Era, my lord. There is a 141, my lord. I am not going to look already. It is a law under 141, my lord. 48 important, my lord.
Para 48.
Yes, my lord. My lord, 45 also important. Era 45. Case 283. We are firm opinion that once the court is interpreted the provision of statute to contest constitutional king has laid down that ground of arrest has to be conveyed to the accused in writing expeditiously. The said ratio become the law binding on all court country by virtue of Article 141 Constitution of India. 48. It may be reiterated that the cause of repetition there is a significant difference between the reason of arrest and ground of arrest. The reason as indicated arrest may be purely formal parameter to prevent the accused person from committing further offense, for proper indicators to prevent the accused person from causing evidence or disclose temporary such to prevent arrest person making endorsement. Those reasons would commonly apply to the person arrested on the charge of a crime where ground of arrest would be required to contact all officer which necessitates the arrest of the accused person. Simultaneously, the ground of arrest informed in writing must convey to the arrested all basic facts on which he was arrested, so to provide opportunity defending
This is
himself.
the new thing we learned from this chapter.
Yes, ma'am.
This is a new interpretation
Yes, ma'am.
of an existing provision. This is always there.
Yes, ma'am. Next, the
Investigating
ground of arrest.
agencies also did not know.
Thus,
They have
ground
also
of
learned.
arrest invariably personnel to the accused cannot be equated with reason of arrest. Because I was arrested 2.5 months before, there is a statement they say in the petition. That statement is available, not everything is available. They should say that you are on the basis of statement of co-accused, you are involved in this case, and this is the result. You are calling so and so, so and so. So this is the ground for arresting you.
They are doing it. Investigating agencies, I've seen. Bilingually also they are writing. But still, there are some
This is the
situations they give. But
Yes.
wherever it is not compliant, obviously the defense will get this benefit.
My lord, I have given first.
Can't help.
I want to show one judgment, my lord. Recently, my lord, there is a judgment Karnataka High Court. I have given first judgment, my lord. It's right. Here, one Karnataka judgment, they have produced my lord NCP. In our court, my lord, Honorable Justice, my lord, Honorable Division Bench of Honorable Justice, that has been distinguished on the basis of National Investigating Agency judgment, my lord, that earlier judgment will be followed. Later judgment will be not followed. Although that judgment has never said that Karnataka judgment, it is violated Article 21. I am reading that judgment, my lord.
It is here in the compilation.
LOC, take this judgment. LOC, read that judgment. Everything will come. No.
Give me the name and take it up.
Yes, my lord. A criminal that 234/2025, my lord. I have to take it. You also can take this judgment. That Dawson judgment has been distinguished.
I'll just have a look and give it back quickly.
And that Gihan Kumar will follow, that judgment said. And considering this judgment also, my lord, I am not reading, my lord. Another judgment has been passed by our High Court. I reading that judgment. First judgment, you have already note down that judgment. In that judgment also distinguish this judgment, and ultimately Gihan Kumar will be followed. This is the division bench judgment, and division bench judgment will be subsequently followed by this single bench. And I have no direct communication with them. And I am not arguing on Psalm 37. No direct communication with the main accused. Commission. And what glorification from glorification that line has been found later. In, I think the big person behind the model that Muslim have been also available with me. That has been discussed either behind Kumar or Pobil Purpose. What to see? Sorry, something. Will do best. Oh, very old. That has been following. I don't know what to start behind. And another judgment is there, Manna, in respect of 48, my lord. I am giving you lordship opinion. I have given.
She's also doing a good job.
One judgment I have given, my lord. Same line. of- Yeah. Regarding provision of law, let's see, behind one is necessary.
No, it's here.
Regarding provision of law, the provision of constitution for the. No, we all, with regard to the facts of the case.
No,
How I come to the law. What's it, the is submitted one judgment that, earlier judgment will be followed. So today, for within the, what's it from the state, they are the same of place value. Check whether each judgment will be in the constitution of the religion or the high court. If there is a completing judgment.
Ordinate bench. If
Yes.
it is same strength, quorum is same.
The submission for the division bench was that the judgment which contains the details, that should be followed by the. Like,
Details.
yes. What's it now, what's it, this judgment. That this is the latest judgment of 14/8/2005. Yes, or division bench has held that the anti judgment will be favored. The prosecuting judgment was not placed, made inquiry. Or report relied on judgment of national insurance commission. But what's in that judgment? Plus, the subsequent judgment was that it was held that late judgment will be prepared. Here, Lordship may please to see all the judgments. The way put up, then, one such case, the behind are all judgments were taken into consideration. I have to place paragraph 20. Please.
Yeah, now I remember. I've not read the judgment, but I've come across this.
Yes, sir. Every state of Assam. Please follow. Paragraph 20, delay in furnishing ground of arrest cannot be itself constituted very ground for grant of it. Page 15.
Delay.
Yes. When delay is there, there cannot be ground. Here, lots of we have supply, but your current of ground of arrest that contains everything.
Both are. Quorum of both the judgments same.
Yes, forum is set. Now, doctors to see which judgment contains the details. Which is not convinced, then this judgment cannot be said to be current because all the judgments. Not the honorable Supreme Court, they will take into consideration. And placing for paragraph 20.1. Delay in furnishing ground of arrest cannot itself constitute valid ground for grant of bail. 20.1.1. The Senate counsel for the arrestment of the accused contained that the arrest was illegal as the ground of arrest were not furnished immediately in writing, thereby violating Article 22(1) of the Constitution and Section 50 CRPC or Section 47 of the DNSS. This submission, however, is devoid of any evidence. Then 20.1.2. Article 22(1) of the Constitution maintains that no person who is arrested shall be retained in custody without being informed as soon as may be on the ground of such arrest, or he shall be denied the right to consult and to be defended by the legal practitioner of his choice. Similarly, Section 51 of CRPC requires that every police officer or other persons arresting such person without warrant shall forthwith communicate him full particulars of the offence for which he is being he is arrested or other grounds of such arrest. Then 20.143.
Also that warrant, warrant issue.
Here also they have been, he has been arrested in connection with obvious case.
And yeah, and
And the punishment is more than, minimum is 10 years.
yes.
Can be extended to 40 years. Section 35 will not be applicable in the budget. Now let's say, 20.143, the constitutional and statutory framework thus mandates that the arrested person must be informed of the ground of arrest, but neither provision prescribed a specific term or instances upon which the written communication is in every case. Judicial precedents have been verified that the substantial compliance with this requirement is sufficient unless demonstrable prejudice is sought. Then 20.114, in Bihan Kumar versus State of Haryana, it was reiterated that Article 22(1) is satisfied if the accused is made aware of the arrest grounds in substance, when if not conveyed in writing. Similarly, in Dasarati Chandra Reddy versus Indrapati, it was observed that when arrest is made pursuant to warrant, putting out the warrant means to sufficient compliance. Both these post court of counsel decision verified that the written individual ground are not inflexible requirement in all circumstances. In 20.1.5, while section 50 CRPC is mandatory, that was consistent judicial approach has been to adopt a pre-judicial oriented test when examining alleged procedural laws. The mere absence of written ground does not factor render the arrest illegal unless it is results in demonstrable prejudicial or denial of fair opportunity to defend. And 20.1.6, the High Court, however, relied heavily on the alleged procedural lapse as a determinative factors while overlooking the gravity of the offense under section 302 of IPC and existence of prima facie case. It noted that in failure that there was no mention in the remand order about service of time of arrest under para 45. The arrest memo were allegedly template based on not personalized. And every eyewitness not stated that they were present at the time of arrest or has signed the memo. Relying on the content concept, this is Union of India and survey requester. It concluded that from 3/3/2023 onwards, failure to start detailed written and individual ground of arrest immediately after arrest was violation entitled the accused to pay. Can you accept 20.2 is important? In the present case, the arrest number and demand records clearly reflect that the respondents were aware of the ground reason for their arrest. They were legally represented from the outside and applied for bail shortly after the arrest, evidencing an immediate and firm understanding of proposition. Now, the clear has been placed on the court to establish that any prejudice imposed due to alleged procedural lapse in the absence of demonstrable prejudice such as irregularity is at place with durable defect and cannot by itself warrant release on bail. As indicated above, I could make it as a cumulative reflex while establishing the reality of the charge under section 302 IPC. In existence of prima facie case, its reliance on content concept in public interest is displaced as those decisions can materially different factors in statutory context. The approach adopted here is inconsistent with the setting considered that procedural lapse in punishing ground of arrest, absent of prejudice, do not expect to render custody illegal or attempted accused. Calculation and interest, courts not expected to render finding in the very then 20.3, appreciation of evidence of the bail stage impermissible. Then 20.4, filing of charge or lengthy list of witness does not justify grant of bail. Then 20.5, the court says that post bail good conduct, it cannot be ground for arrest. Then 22.1, nature and gravity of offense is to be considered by the page 25. And here, all these things are there. And what with our high court,
This Are you saying that the interpretation of this particular judgment means that a prejudice test is introduced?
Yes,
Prejudice.
yes.
But which judgment should we follow?
What's it in my?
Because prejudice test is not easy.
Yeah, what's it here?
It has an element of subjectivity.
Taking into consideration also the judgment which is the more detailed discussion is there that is to be considered. Because here also all the previous judgment will be taken into consideration.
No, but both are of equal strength.
Consider the same strength, but there is a law. Okay,
You have to see that judgment.
at place figure also.
Because otherwise for
No, no, see,
for us or
when there is
below
a,
us.
there is a complete of this same. But same strength of both, which judgment is to be followed. But see, in this case, see, in submission the judgment is from this more details that is to be taken into consideration.
Can you help me with that?
But see, say,
That is an area where real guidance is
yes, but
necessary.
applies.
Because for the High Court and of course below, in matters of not bail matter, but general principles.
Yes,
If the coordinate bench, same strength bench disagrees with another, judgment, one cannot lay down a different law. It has to be referred to
Yes,
Chief
but
Justice for higher bench,
But-
not a bench.
Yes, my lord. But yeah,
But these principles not
division
applicable
bench
to
has-
Supreme Court.
division bench has been decided this issue, my lord. That is why I'm submitting.
Both are division also.
Yeah,
Division bench.
my lord,
This issue has been
like
decided.
this judgment he is arguing.
Yes, sir.
That has been divided, our division, and Honorable Justice Michael Jotham
No,
Kumar,
no, no.
that judgment has been distinguished. I am given that judgment. my
I
lord.
place my atomic division means pay for number 5. If we have to add some distributes lots of those cases we put some addressing.
Right.
So decide the issue. Whether which judgment will be followed when there is a complete judgment of same thing sometimes.
Of the Supreme Court.
Yes, sir.
But here, as I said, in High Court, we cannot take a different view. It has to be referred to a larger bench.
Yes, sir.
May I submit, my lord? One thing is important, my lord.
Not
What-
applicable to Honorable Supreme.
My lord, what he is submitting, it is against the judgment of the apex court. I am coming, my lord, there is reason behind it, my lord. This thing has been happened. 2008-10 SSC 1, Dayanand versus official liquidator, my lord. If your lordship go through that judgment, my lord,
2010,
2008-10 SSC 1, Dayanand versus official liquidator. This type of, my lord, judgment has been discussed, my lord. I am reading paragraph 78. If your lordship got the judgment, my lord, paragraph 78,
17.
78, 83, 87. I am reading that judgment, my lord. Very important, my lord. Because, my lord, this type of, only one thing, my lord, 1 minute. There has been several instances of different benches of the
Can
High
you-
Court.
Mr. Can you read?
No, see, my learned friend is probably he has to make some something complete.
No, he wants to just
The-
intervene and read that part.
So,
So he wants to read one paragraph of that judgment. And read.
yes,
If you permit, then he can. read. Because you are arguing that. Okay, you can.
sorry, ma'am.
He has permitted you. You can just
I am extremely sorry, ma'am.
mention.
I
the
get
fact.
it. No problem. My lord, paragraph 78 at that judgment. my lord. There has been several instances of difference of High Court not following the judgment order of the coordinate and even larger bench. Now larger bench has passed a judgment. my lord. That this judgment will not follow, Bihan Kumar will follow. Honorable Justice Michael Jotham Kumar and other judgment. When in some cases, the High Court have gone to the extent of ignoring the law laid down by this court without any tangible reason. Like has been instances in which smaller benches of this court have either ignored or bypassed the ratio of judgment of the larger bench, including the constitutional bench. These cases are illustrated not adherence to the rule of judicial discipline, which was sine qua non sustaining system in Mahadevlal, Kanodia, and Administrator General West Bengal. Then your lordship, if anything discussed, I'm cutting short, para 83. In Pratap Chanda Parija, Pramod Chanda Patnaik, the constitutional bench noted that two learned judges denuded and the correctness of earlier constitutional bench judgment of Bharat Petroleum Corporation and returned the same despite of the fact that the second one refused to reconsider the earlier judgment. We may point out that at the outset, Bharat Petroleum has been mentioned by the then had considered somewhat similar question. Two learned judges in that case doubted the correctness of the scope of activity with certain provision of earlier constitutional judgment, according the matter referred directly to a constitution bench. The constitution bench then heard the matter look, view the decision of the constitution bench to learn that discipline obliged to follow him regardless. At that point of time, most bench of learned judge could have ordered the matter heard by a bench of 3 judges. The learned so and so. Ultimately, my lord, 87. For the view taken herein, I regret. Have you logic of 87? I regret the express my inability to agree with the brother so and so regard to criticism of various other pass in my itself other benches. I am opinion that it is only appropriate to do so. One bench of the court is tried does not sit appeal over the other benches when it coordinate bench is equal to appropriate as similar mention larger bench so and so. The main theme is that, my lord, now, my lord, division bench has passed an order that Bihan Kumar will follow. That order got the finality. If they are agreed, they can file an appeal before taking the apex court. They are not filing the appeal, man. And as on today, this judgment of the honorable division bench will be followed. And he has submitting, my lord, that
We have to follow because we are single.
yes, my lord. That is the judgment, and that is exactly follow honorable justice Midul Kolkam one judgment, man.
Now you please.
Yes.
Sorry for the interruption.
There is no quarrel. To see the impression. Benches taken into consideration national insurance strategy versus foreign strategy. That was what the my submission. We respect. That's the law laid down in that case was different one. They were so Sarvaj, then was principate by the bench. That's why let's say the matter went to Supreme Court. In paragraph 15, also all these judgments were of higher court, not a similar step. And in that logic, the Supreme Court held that the earlier judgment should be followed. But here logic case is different. I don't know. Lordship that is to be taken into account. Yes, Lordship. Lordship is done by the division bench. But today, Lordship, I abode for the division bench with respect to similar case Lordship. Then that has been fixed on
Maybe some holding will emerge.
yes, Lordship. And this is the important question of law to be decided by the division. I know Lordship, there is a judgment to be followed by a Lordship. The Lordship has no option but to follow the discipline, judicial discipline, in the judgment of the division bench is to be followed. But what's it not to do? At the same time, what's it is to see what is the what circumstances are taken into consider the division. Yes, Lordship, Lordship cannot work on that division. Lordship,
Fair.
that is Lordship, that I know also. But Lordship, the law that done by the division bench, whether it is correct or not, should be decided by the larger bench or by the same inspector.
Full bench.
Definitely. The decision are those are there. And what's it with the judgment? Sensing more elaborating, more details. Everything was considered. Compared to the beyond. The leader to what's it to whether what's it will wait to or what's it.
It's fixed on. It's fixed on.
On witness. It was listed item number 2.
Liberty matters. I can resolve it, but cannot be so long also. The division bench judgment, I will take it out properly.
Yes, my humble submission before Lordship is that, my lord. I am paragraph 88 and 90 has said, my lord.
Of Dayanand.
No, Dayanand, my lord, that judgment. That judicial discipline is an inbuilt mechanism system. Judicial is a demand when a decision of court in the same high court is brought to the notice of the event is to be restricted binding subject to the court to the right and correctness in the permissible court will open refer to question larger ban. This minimum in discipline and discomfort the para 90. We are distressed to know that despite several pronouncements on the judgment, there is several substantial increase in the number of cases, violation of basic judicial discipline. The learned single judge benches of High Court refused to follow, except the verdict law laid down by the coordinator, again larger bench by the citing minor development of the ground. Doing so, therefore, it has become necessary that disrespect consideration discipline. My humble submission before your lordship is that, my lord, as on today, my lord, this is the law. And my humble submission, I am not appearing in that case, my lord. If I am appearing in that case, my lord, I said directly state the division bench, as already decided by the division bench. If you are disagree, you can refer to the 3 judges benches. But that does not mean, my lord, we will not follow. And second thing, this judgment of the division bench was long back. That order was not filed and appeal, my lord. By the, my lord, same authority, my lord. Not same authority. My lord, other, yes, my lord, other, my lord. As I am not, I am withdrawing my submission, sir. My lord, okay. My humble submission before your lord, as on today, my lord, this is the law, my lord. And something will be happened solely on over sorry, some, my lord, side will be barred, my lord. That will not, my lord, will not. As on today, this is the law, my lord. This is my humble submission before your lord.
From the point of view of the law student, we are all law students.
Yes, sir.
Doctrine of precedent is to bring certainty in law.
Yes, sir.
Think beyond the legal community also. People have to know what is the law.
Yes, ma'am.
It's clear. That is one of them.
And that
Let us
has,
see what happens.
that has been distinguishing in the bench as well, ma'am. And
Anyway.
that's following NDPS case in our cases also.
So I'll reserve this.
Commercial conduct.
I'll have to study also. It's okay. What? Anything else? Anything else?
No, sir. Regarding involvement of the petition, his involvement in other cases.
That was I was released on bail. I was
Oh,
released
you
on
want
bail.
the merits of the case.
Yes, sir. That
That I will see, have
Yes.
to see.
we have filed objection that
That I have to see.
I was released on bail and that case, ma'am.
And then which other, assistant. But, NCB.
NCB.
Assisted by MB.
This is the man I was released on bail.
Learned, learned counsels for the NCB. Arguments. Judgment order is resolved. Both sides have given me enough homework for the weekend.
Yes, sir.
No weekend.
Yes, sir.
And
That
we
is
have
the
Lok
judgment.
Adalat also.
That is judgment I was released on bail.
Okay. I'll keep it. If you need any particular copy, then I'll make photostat and collect it on the. I'll try to.
Okay. This is a very interesting point. Probably our division comes in this time. Right?
Which point?
So regarding lordship, which judgment will be applicable? Can the lordship might not be absolutely a question.
No, ideally, actually, whenever there is conflict of legal principles, laying the legal principles between two equal benches, which you refer to.
We prefer to, but nowadays, lordship, many judgments are there. Lordship recently, there are some judgment which is about 3 judges. That has been taken into consideration 2 bench and 2 judgments. Still, it has not been referred to.
But there's conflict.
Yes.
I am giving the law.
You know, I had read somewhere that, of course, in our country, it's simply not possible. You know, we are already over. In some countries, originally, like say, some of these Western countries, USA, the highest court people, in the highest court, all judges sit together. That is why it's one court. I read some.
I am giving the, wife is the malam affidavit.
Which country it's not possible? Yes.
Yes.
Simply.
Yes.
Much of it.
Affidavit Bibi is the wife.
Take out 2 minutes. Oh.
So, council also waiting. My submission will be Lokip.
Yeah.
Lokip is aware he is in maximum period is 60 days. Now 53 days is completed.
And the coordinate bench and the name accused has been released on bail.
I remember.
Okay.
So, I was sick also.
And
Let me hear what you say. The instructions were clear.
Yes, case diary along with status report of the authority.
any condition, Lordship, because petitioner cannot move, Lordship, because of the sugar.
Oh, medical report.
Health status report.
Have a seat. Let us take 2-3 minutes. Third, Samil and counsel for the accused. We bottom landed additional. You want to make some submissions?
Because I have pointed out the material secondary.
Yeah, we think.
164 statement is also. We took, you not only will get those number, common level, but also start taking money provided by the company, the job seeker. Divided by 164 statement.
The subsequent bail petition, earlier bail petition is rejected by this court on these arms. Copy has been fairly annexed with this petition. Learned counsel submits that in custody for 53 days and also suffering from ailments. It's the learned additional people submitting the case diary contains that the investigation revealed incriminating materials against the present accused. And the relevant areas pointed out in the case there. These also, the materials indicate, submitted for the materials not only indicate his involvement, but also indicate that he illegally printed some materials, the press that nobody. On the basis of the contention about health condition of the accused, the medical report was called for in the superintendent of called for from the office of the superintendent of district jail number. The report by the jail doctor has been submitted. For perusing the same, I find that apart from some of the health difficulties pointed out in the petition, it has also been found that he has been suffering from gastro bleed, for which he was admitted briefly in Nalbari Medical College. Learned counsel has also placed order of a coordinate bench with regard to a man named accused who was granted bail on 8/9/2025. Next matter. though there are significant incriminating materials against the petitioner, against the accused. And objection of the learned additional PP, which also bear relevance. Yes. I am of the considered view that considering the health condition, projected health situation of the accused, and also keeping in mind the fact that co-accused, FIR name, been granted bail in this case, dash. This accused can also be released on bail at this stage, subject however to suitable conditions. In such view of the matter, 30,000 pounds subject to the conditions that he shall remain available. Number two, he shall cooperate with remaining investigation. He shall not hamper or tamper with evidence, including document evidence. He shall not intimidate or try to influence witnesses. He shall not hamper or tamper with evidence. He shall be available for trial in the event of charge sheet and framing of charges. Violation of the bail conditions. In case of violation of bail conditions, the prosecution will be at liberty to move an application for cancellation of the bail. So return back the case. Apply this. Some materials.
Considering the bail condition and period also.
Yeah.
Considering the bail condition.
Let him take treatment also. It's okay.
Public. Maybe the. In this case, the petitioner, he was so arrested in this particular case. This is one of the cases that has been transferred from Manipur, and I'm in custody since 9/12/2023, for almost 1 year and 10 months now. This is the same case in which the grounds of arrest and notice to his relatives were not given apparently. And if my learned friend can overcome that, then there are a few other points that I will come to later on. And apparently, my learned friend has, while their objections, in para 21 of the objection, page 68,
Fine. Ma'am, you filed a objection.
Yes, Lord. Para 21, it starts from page 67, so the relevant portion is page 68.
Para 67, page 67.
It starts on page 67, but the relevant portion is in page 68, last para. Last 3 lines, then it continues on the next page. It is further submitted that the reasons, grounds for whereas of the accused applicant have been clearly mentioned in the application submitted before the Honorable CGM Court. And the same reason grounds were subsequently mentioned in the order that so passed by the Honorable CGM Court, allowing the prayer of the CBI for arresting the accused applicant. Further, it is submitted that since the accused was locked inside judicial custody, the information regarding the arrest of the accused applicant has been conveyed to his family members over mobile phone, which is provided to the CBI by the applicant accused only. The same has been mentioned in the arrest note prepared at the time of arrest the accused person. This is the this is what they have stated regarding the grounds of arrest. Apparently, there is no grounds of arrest were provided to the applicant below. And on last occasion, your office called for certain records from the law court, and that has also come.
Scan copy.
Scan copy of the record. I also wanted to see, have a look at the application, what they have filed in the law court below.
Which is part of the scan copy.
Yes, madam.
Application for police custody.
Yes, madam. This one.
Okay. Next.
And accordingly, from their objection itself, it appears that they have not provided the grounds of arrest to the accused. Nor that is the notice was issued to their relatives. 50 year notice was not issued.
We call for the case diary.
Already record is there.
No, the case diary.
Case diary mostly it will not be recorded. Already that subject they filed their subject in the court of law. And there is one more issue, my lord, that will come to later on if they can overcome this.
Some of the order sheets. Some petitions.
Apparently, there was an bail application earlier in the lower court below, my lord, in CCM court. That while that application was pending, CBI has filed a search sheet in the lower court below. Search sheet was filed on 1/3/2024, my lord. Apparently, the accused petitioner, he was arrested on 9/12/2023. And the offense was 384 and 25(1)(b) of the Arms Act, IPC. 384 IPC. And 25(1)(b) of Arms Act and 3 and 4 of PDPP Act. Apparently, the time date for filing search sheet was 60 days. What the investigating officers they have done, they filed the search sheet beyond 60 days. While filing the search sheet, they added 395 IPC. The moment 390, but while adding filing search sheet 395, they didn't take the permission from the honorable magistrate below
To add the section.
to add that section below. That has been done only to make because they realize that the search sheet has not been filed within time, as they will be entitled to default bail. Only because of that 395 has been added below, so that it becomes 90 days below.
That will be determined by the FIR registered sections.
Yes, sir.
Statutory period.
Yes, sir. FIR, I have an
But
exact copy
of
of
course, there
FIR.
can be plus minus of sections at the stage of FIR charge sheet.
Yes, madam.
But
The
statutory
maximum
period,
punishment at that time,
the best of my knowledge, would be governed by the penal provisions
yes, madam.
which are registered.
Yes, the maximum punishment was at the time of on the basis of the FIR was 7 years. Madam.
Registered and added.
Added. It was not added, Miller. They filed a search sheet adding 395 Miller. What they have not taken the permission of the magistrate below.
CBI court.
CBI court.
So anyway, so now
That part I'll come later on, Miller. First of all, they have to satisfy that they have to issue the notice under 650 and 50A.
this other case is also same.
Yes, same thing. Only the difference is the date of arrest, Miller. In that particular case,
He was arrested in two different cases.
yes, Miller. Earlier they were arrested in another
No,
case.
they are two
That was in September.
Two different cases. And
One
the
FIR.
FIR is same.
In both the cases, FIR the same. In the other case, Miller, he was arrested on 5/12, Miller. Only the date of arrest is shown arrest is different. Your lordship will kindly find the FIR of the present case in page 16, Miller.
Page 16
Yes, Miller. Of the application, Miller.
in the main application.
In the main application, Miller.
It's 1/6.
1/6. Miller. Annexer 2. This is the original FIR filed at Bishnupur Police Station, Moirangkeng Police Station, Manipur, in Manipur. FIR number 14428/2023. The sections were 143, 148, 442, 427, 384, 380 Miller. And 25(1)(b) A of the Arms Act and 3 and 4 of the PDPP Act. Miller. The allegation was that what will kindly turn to page 17, Miller.
Yes, I've seen looting of arms.
Yes, Miller.
Then
From the IRB battalion.
FIR is at page 17. And subsequently, this case was transferred to CBI. They re-registered it as FIR number 20 RC 29 oblique dated 24/8/2023, CBI SCV Calcutta. Right. Okay, should I go to the yes, please?
This method was extensively heard in religions. To that effect, there is a specific article also because some scan copy from the QR code below.
Right.
We have also the copies and that copy I have already provided, which shows.
In your additional affidavit,
No. On the last occasion, I have.
written objection.
Written objection is there. Subsequently, I was asked to produce certain order of the application of the IO, where he has paid for production of the accused person. So it was a production warrant. Now the dispute is with regard to that there is a no ground of arrest. In this case, this is a warrant has been issued, and in the case of warrant,
Not warrant, production warrant. Warrant and production warrant and custody warrant. Your also very well knows that.
Anyway, true, that's true.
in this case, warrant has been issued. Now the question is under what circumstances warrant can be issued. Here, the accused person is in the custody of some competent authority. He was not absconded. He was under the control of somebody. As such, if he is required to be produced, there should be a prefix production of production warrant. A simple warrant cannot. Production
But he's
qualifies
already in
warrant.
custody.
And it's vice versa, warrant qualifies production. Because he is neither absconded nor he is disobeying, so that the warrant can be obtained and police will go and arrest him.
It's a warrant for production.
Warrant for production. Because he is in the custody of some competent authority.
Is the production copy of the warrant is there?
Yes, sir. On the last occasion, I have given.
There's a call for the lower court below board.
And lower court below application is there. IU has requested for issuing the warrant. And to that effect, your lordship, I have already given a judgment. Of the
Where not
Supreme Court.
production warrant? The production warrant is not the same thing as an arrest warrant. Person is
Because he is already in the.
no,
custody.
he's custody in another case. Production warrant is issued to bring him in this case.
In this,
And after production warrant is submitted,
he has
then,
been arrested.
then he's prayed to be shown arrest. Wait to be shown arrest.
Yes,
right?
but no ground is required. That is very clear from the Supreme Court judgment.
No,
Warrant itself
no,
is a
in
ground.
that judgment that, what is that, just now we perused that judgment. The coordinate bench judgment, this is Patiwala and Madhu. That judgment, yes, which we just discussed in the previous case. In that judgment, it has been said, we read, discussed, that arrest of warrant itself is the
Is the ground.
intimation of the grounds of arrest.
sir.
So separate, this is non-necessary, that's a non-intervention. But in a production warrant, these grounds of arrest are not mentioned, isn't it?
It is not mentioned, but the thing is that warrant production is qualifying. It is only qualifying.
No, you
Because
can
the
submit
person is under the custody of some statutory authority. CBI person cannot go or any IU
True,
cannot.
but the thing is that,
directly bring it.
yeah.
That authority is not this.
But the mainly because a person is brought with a production warrant and there is a prayer for showing him arrest in the particular case,
Yes,
does
yes,
not
yes.
mean that the court will automatically show him arrest.
But it is there in the. order.
No, that's why I said. So, so let us see that.
I have the judgment on the last.
Separate
occasion.
grounds.
Of the Supreme Court of Mr. Justice Padiwal.
No, that's why he's saying, see, does it say, does the judgment say that production warrant and arrest of warrant are the same one and the same thing? Number one.
Yes.
Number two, does it say that like a arrest of warrant of arrest, even a production warrant is enough notice of grounds of arrest? It does not say so in my humble. But we can always look it
I
again.
do.
We
but
can,
the
we
thing
can
is-
look it again.
Thing is
But
that
you
he
can
is
submit
not
it also.
outside of any
You can
computer
submit.
authority, or he is not roaming like this so that an warrant can be issued and the police will go and arrest.
This is the
Since he is
same gentleman.
in the
Yes.
custody of some statutory authority, that is required.
Can I have a
Another ruling.
copy of the production warrant? No, no, don't go into rulings such as madam, just for the moment. Request for production warrant.
Yes, Your Honor.
Okay. In your production warrant, the prayer, the application, it has been mentioned, right? That why he needs to be taken into custody. The reasons are there,
It
but,
is there.
but this does not go to him, like the production warrant copy is there or it's not there. Is copy of the production warrant available? You don't have to feel bad if it's not there, but I'm just asking whether it is there or not, so that I want to have a reason. I want to have a look at it. And the learned CJM discusses those reasons. That is true. Discusses these reasons.
I can give one photocopy,
Yeah.
which has been provided by a jail authority, because that day your lordship has asked certain copies to prove that this warrant has been.
No,
gone
because,
to jail authority.
what production warrant has been, what is narrated in the production warrant?
So-
Like say this order 9/12/2023 passed by the learned CGM Metro company. It discusses the
Yes,
the
I.
grounds
Yeah.
of which arrest he has been ready to be shown arrested.
It will be done this way.
And this is
Complying with the order in the warrant of arrest, it has.
whatever I have seen a couple of. production
And the
warrants, it
application
does not have
for the
anything.
police custody.
Only this thing is mentioned. The so and so is necessary for production.
Application for police custody, remand of accused license seen, son of so and so, produced before this honorable court for a period of 5 days.
Yeah.
It is the evidence.
See, 47 and 48 notice, or 50 and 50C, 50A notice. These are for the accused and his relatives. So, Bihan Kumar, all there's one specific paragraph. I don't remember the number of the paragraph where, earlier we also used to think that, what are the forwarding, the reasons given of ground of arrest in the forwarding is sufficient. But it was explained in Bihan Kumar, in that paragraph, which I don't remember the number, that is for the court. We are talking about the grounds of arrest for the accused and his relatives. That is the distinction. We also learned, many of us also thought that is only grounds of arrest, sufficient. But now, the new interpretation, that is not sufficient.
Subsequently,
So-
the state of Karnataka versus Reverson, it has been dealt with the ground of arrest and in regard to the serious crime, because it is an attack to the sovereignty of.
No,
the
no, that's a different thing. That's true here. Most heinous crimes also, we are having to release because of the application of the law. No, that is that all of us are concerned. The thing is that because the principles laid down, madam, I appreciate that the principles laid down in this TRICA cases from let's talk about Kulkasta and Bihan Kumar, on the basis of which courts all over the country are applying in the new interpretation of the law. This interpretation of the applicability of these two sections, 48, 47, 48, and failing which the person will be granted bail. These sections, there's no qualification. There could have been qualifications to these sections, hypothetically speaking, that, suppose that this will apply only prospectively. This will not apply to this kind of offenses. This will not apply over statutory powers. But nothing has been just unqualified. In fact, rather it has been said that it has not been said that it will be prospective. So by the general principle, the judgments are usually retrospective application there, it has been applied like that. Number two, it has not been see, even in until, they have tried to categorize some kind of offenses, financial crimes, and categorized No such categorization is also there. And as far as statutory bar is concerned, rather than being silent, it has been specifically said that it will prevail over statutory bar because that would have led to tremendous confusion. So since it is not qualified, therefore we cannot really, we are always conscious. Even in certain situations where we know that on merits, bail may not have been justified. Still, since it's the constitutional principles and that too interpreted by the Honorable Apex Court, the courts are heading to are granting bail and probably rightly so. This is my point actually. So we just have to check, madam, at this stage that what are the materials from yours for the CBI about compliance with these two notices. If it is there, it's there. If it's not there, we need not bother it. We can always learn in the future.
Ready because to the police station. When it is handed over to the CBI, CBI is given an application to take the custody. And therefore the production warrant has been issued. Had there been, he was not arrested earlier. No question of production, it is a simple warrant. It would have been a simple warrant. Production is prefixed. Reason being, he is in the custody of some competent authority or some statutory body. CBI has no access to that.
So in
Get
support,
an access to that. This
So-
production warrant is required and some order from the competent authority is required to be produced. Prefix is not going to dilute the nature of the warrant.
okay, that is your assumption. Anyway, so just for a moment.
And I am coming to this
This,
this judgment also, this judgment, wherein it was challenged in the Supreme Court. Supreme Court has taken into cognizance because the bail was granted only on the ground that there is no ground for arrest. And though he was languishing in the
so
jail
some
for
of these
last 2
matters
years,
can
last
go
2 years,
and probably
his bail
should
is
go
cancelled.
so that we have more clarity.
And here it has been discussed very properly with regard to the warrant of arrest and valuable cases and apprehension of arrest. It has been discussed here and distinguished each and every steps of the bail.
Gone through it.
So you're in support of your contention about the non-compliance with the notice that, have you got any notice?
No, my lord, absolutely not.
No
my lord.
notice.
No notice. Production warrant.
So
After he was produced in
your-
court, only after that he was arrested. my
No,
lord.
47, your contention is that 47?
No notice, no
Not
notice
there.
was, no notice was.
48
received.
notice?
No,
Not there.
absolutely not. my lord.
And madam has said in that,
There
that a contention.
is no question of issuance of notice.
That is her submission.
We have to pray before the magistrate.
And
That
the
is
grounds
notice.
in the
Order
petition
itself
are
is
sufficient.
notice.
That's not her.
Petition that is filed before the magistrate only. Lower court magistrate.
That is her submission.
Yes.
Submit and that relying on this decision, the gravity of the offense has to be seen. And it is here actually what I understand is that it's prejudice test. Prejudice.
Lordship, the notice itself is the order of the magistrate is notice. It itself is a notice.
In case of
Because
warrant
the
of
order
arrest.
Given by Mother. Yes, in case of the arrest. Because the court has given an order to arrest. And
So-
without the permission, you cannot arrest.
No. So again, we can go back to that question that is production warrant same as a arrest warrant?
No, absolutely not. my lord.
It is same as a warrant.
Let her complete, my lord, first.
Contrary opinions.
Let her
You
complete
can have
first.
your opinion. No issues. I can always have an opinion, but I have to justify why I'm having that opinion, right? So that's the thing. I can have an opinion. Why not?
I made a lot of research on this issue, whether production warrant is one and the same. Your lordship, it is not available.
The warrant
Even
is-
for the academic purpose, it is written warrant is and production warrant is one and the same. It is only qualification given to the warrant.
Madam,
Issue which
absolutely
type?
not. Production warrant will be
Which type?
on.
It is a.
That's a submission.
So it is academic field. If you have
Not
any-
really academic also.
we will get aware of.
Because madam is saying that production warrant and arrest warrant one and the same thing because
It cannot be wrong.
he's being brought for arresting.
Yes, you.
That is
Because
what-
he is in the custody of
He's
someone.
already in custody. That is her submission.
Yes, madam.
He is under competent authority. In the custody of one competent authority, he is under the statutory body. You don't have access. Directly he cannot go. You cannot go there to arrest. He has to take a permission. Because FIR is there and regular case is also registered by CPM. Proper procedure has to be followed, and that is why I always follow a proper procedure. File an application before the magistrate. Magistrate, after going through the grounds, issued a production order. Order is itself reflecting university. Had he been the absconder, not required for production. After getting the order of warrant, you can go and arrest him from anywhere of the world. It has been touched page number 25, 24 onwards. All reasons, and it is discussed very clearly. And it has diluted the ground of arrest also in case of heinous crime.
But again, that question, which one should we follow? Because both are coordinate things.
In my case, both cases are applicable. First is in the custody of some public authority. That is why production is required. And we're looking to the nature of the crime, which is heinous. It is attack to the society, the country.
I mean, so.
Manoj, just I want to make one submission. The latest judgment that CS Darshan's case. Few moments ago, you all also has gone through that decision also. And
Some parts of it, not all.
And with regard to that, my learned friend earlier, Mr. Chaudhary, NLA Chaudhary, has placed one judgment of
Division bench.
division bench.
So that's very important.
Yes, ma'am.
But I'm not. Division bench. That is.
That this is not.
Keep it, that is we have kept.
Already that has been distinguished below.
The nature of the crime is may not be
And-
the same, and the circumstances may not be one and the same.
And so far, Mr. Consider this cases there in which the warrant of arrest has been stated. And with regard to that, there is a latest judgment of coordinate bench or High Court also that was passed on 18/8/2025.
These are it is
Well, also, like,
persuasive impetus. So I have given the latest one, 25, of the division bench of the Supreme Court.
in this case, from para 15 onwards, that will be relevant to. In this case, the warrant of arrest and production warrant that has been distinguished.
This case.
In this case. Para 15 onwards.
Yeah.
15 onwards. Okay. Okay. Relevant around the para 18. In this case, distinction has already been made with regard to the warrant of arrest.
This point is nothing. So sorry, like, no. Forgotten, no, I did not know. The chronicity it has been clearly laid down, and I've gone through chronicity so many times for applying it, the formulas, MACT cases. But it has been said which paragraph is not clear, but in the judgment of this judgment, the division bench, that when there are conflicting decisions of equal benches of the Supreme Court, earlier decisions should be followed by the high courts. So the honorable division bench of this high court was also presented with that dilemma, two conflicting decisions. So by referring, it's not the division bench's own law, the division bench's own principle laid down. It was not necessary because that principle was already laid down in Procedural, which is a constitution bench, but I have to locate the para. So that's relevant. That means
The para number.
regarding which judgment to follow, that means the solution is already there in Procedural itself.
See, ask is for the CD, I think, in the CD.
What your CD will be required in your admitted facts.
To tell you frankly, in any bail application, sometimes the court feels handicapped without CD. CD is relevant for every bail application. Though we should not overdo it. It's also there.
Already metro, it has been certified.
But still, a background leading to the charge sheet. So, but adding arguments and something.
And with regard to
You have
the
given
imposition
sufficient
of
materials
section
also.
395, because the matter is under investigation. So maybe earlier it was 60 days statutory period. It is not that to extend the period 395 has been imposed. The circumstances or during the course of investigation, whatever revealed, and that is why.
Oh, charge sheet, as I said, charge sheet plus minus can happen.
Yes.
But last minute addition.
That is just,
That is not.
certificate was filed
Yes.
just before the expiry of the 90 days.
That was not going to vitiate. You don't have to take permission to, give different penal section in the charge sheet.
Yes.
But
Even
it will not any last minute addition of a new section will not tinker with the statutory periods. That will be unfair. It
In
cannot-
that case, I will be entitled to default bill. That thing will come into picture.
There can be plus minus at every stage.
Yes.
FIR, then charge sheet, then, cognizance, then charge. And ultimately, if it's trial, at the time of, if there's a conviction, plus minus, can be plus minus at every stage. But anyway, so, no more arguments are necessary. I should close it.
Reading one line.
I can should certainly read, but,
Substance case.
so if I reserve it, can you, give me the CD in the meantime? Or should I fix a date for it? Monday or?
Even your document may fix the date for reserve the document independent civil
Can
proceeding.
you- I know, we have a extended weekend. But you have ensured that I will not have enough homework. But anyway, we have local Saturdays differently, but CD it will be desirable to have a CD because there's contentions.
Yes, I agree with you.
There are differences, serious differences of what should be the position on both sides. And I respect your views. I respect your views.
That will reveal all the background of the
Give
investigation.
bring the CD. So when can you bring it?
Day-to-day entries. So one line I just.
Yeah. Can you go and fix a date for the CD?
25 of persons is. My learned friends is saying about the deployed day. One line will reflect everything. Filing of charge sheet or lengthy list of witness does not justify grant of bail.
Yeah.
And thereafter, there is a discussion.
There's a general, only on filing of charge sheet.
That filing of charge sheet or lengthy list of witness
Which
does
para?
not justify grant of bail.
Which para?
Page number 25 of Darshan's case. This is latest one of arguments. Justice Parliament.
We all know the finer points of law can be
This
very
is
challenging.
authored by R. Mahadevan Justice.
Yeah. Para?
Just last 20.4,
2.4.
page number 25. In this, just now I have handed over.
Yes.
See, Darshan's case. This is a big judgment.
From the SC observer, that one.
This is
Oh, yeah.
in.
Uh, 20.6.
20.4, page number 25. This discussion is there right from the previous paragraph, but it is being pointed.
20.4.
Last line. At page 25.
No, that is fine. Mere filing of a charge sheet would not justify bail.
My grandmother is paying for the default bail or charge sheet has been filed. So looking to the nature of the crime,
That is, this is
and it has been discussed also.
filing of a
subsequently.
charge sheet. That means completion of investigation can be a ground for granting bail, but it is not a right, indefensible right. It's not an indefensible right.
And that has been discussed.
You have to see merits also.
This judgment has distinguished each and every point of the bail and the circumstances and the nature of the crimes. And with regard to the ground of the this required to be given a notice for them, that is also has been discussed.
Yeah,
I just
but
don't think it has diluted the enhancements.
two. The thing is that to coordinate benches of the Honorable Supreme Court, one lays down the principles unconditionally, no qualification. And this judgment, from what I have understood, so far, it seems to be qualifying those principles, prejudice test, gravity of offenses. Now, the thing is that for counsels, of course, I mean, whichever comes to your line of thinking, that will be placed.
And with regard to
But
this in our
Pranay Sethi, I have to see that exact paragraph. But this is what has
sorry,
been
paragraph 15.
paragraph 15 of
Most
Pranay Sethi.
probably.
Okay, let's check. Pranay Sethi, that is one of the most important principle of laid down there. Then then we have to. In any case, division bench has accepted that.
Yes.
So for us, there's
Because
not much scope.
till that judgment is
Academically, we can discuss. For application, there's not much scope.
yes. Till that is
Not
overall,
no
then
scope rather.
that is a law and order.
Because that's Pranay Sethi is more famous for the fine tuning the principles MACT. Now this standard amounts, whatever, all these many things, but it is equally important for this principle also. Then, and if there's a conflict.
The judgment is very lengthy judgment. We'll go on discussing this, it will take at least 1 hour. Right from, it starts from conclusion, it starts from page 19. And conclusion, headline is given. Conclusion, in both line it has been given.
Should be that lighter to me, so that we understand it better.
That is from paragraph 67. It starts from 19. Each and everything is dealt with.
So let us close documents, but kindly provide the scene. Okay. Can you give it on Monday or Tuesday?
The moment you will go.
CDs here only in Calcutta.
Here. Maybe here in the Guwahati office, if it is there in Calcutta, it will take 2 days.
Arshika Lanak Council, so for the petition for the accused seeking bail here, same order. Addresses further arguments at length. And very learned retainer counsel procedure. Also addresses further arguments at length. Case notes are submitted by both sides. It may be mentioned during that CBI has also filed the written objection. Argument stands concluded. However, the Learned Retainer Council undertakes to submit the case diary before the court. So list the matter on, should we list it on Tuesday?
Yes, sir. That can be done.
Listed on 16/9. In the orders column, should I listed in the orders column or?
Bail hearing.
Arguments for bail hearing. Arguments stand up.
Let's do part or two.
Continue to be. No, it has to be part of because I have. Yes, complete. In fact, I will start working on it. Actual part I'll start writing.
Yes, ma'am.
This judgment with regard to the heinous crime and just
We kept as part of and based on 15/9. 15/9. Arguments concluded. 16/9. 16/9.
Tuesday.
Tuesday.
For bail hearing.
So that's why I asked actually,
Let it be
If
on
we-
16 below.
if we write arguments concluded, then no point in fixing it for hearing.
You're saying
That's
I might
why-
have some queries with regard to the case study
So-
also.
Sixteen. Hearing, keep it on 17th. Is it okay? Let it go. 17th for bail hearing.
Part or
No, it has to be kept as
yes,
part of it.
yes.
Your effort will be wasted.
meanwhile, I tried to search again with regard to the production organ. If anything will be. Acha.
Bail, AB bail hearing, only those where case diary has come. Check up. Not much time is. Hearing matters also. We have to take one of them.
May I please go to it is regarding the Kalapara incident also. Proceed.
Kalapara incident, that one. EW.
Proceed. Assistant engineer also. Petitioner is.
Not getting the time to read these papers. Everyone is, why so many people are apprehending everything? Same one. So, correct. Do you remember the date when it has been fixed?
Also 19/9.
1990. Inside. Fatasil Ambari. Fatasil Ambari, PS case number 127 of them. Or I think 20,000 or 25,000. I think.
Okay.
Only one matter or more?
So item number 2 is also same. It's also assistant engineer.
He is a PWD official.
Proceed. PW.
And say this one.
Same. Proceed. Assistant engineer.
More to 20,000, 25,000. 25,000. It was same. Fatasil Ambari, PS case number 127 to 25.
Deputy.
19.
He's on next. After some time, he's on next.
That's over. 15 minutes. Those,
15.
I'm listing for.
After 5 minutes.
Huh? Otherwise, after 5 minutes, otherwise, we can, it's okay, let it be there after 5 minutes. After, otherwise we'll fix it on Monday or Wednesday. Only 5 minutes. No. Let him do the matter properly. Next, AB failure. Only the case diary is where it's come from. Otherwise, not received. AB 1560. Submitted that case diary not yet received. Issue press reminder. The interim order, interim bail in favor of all granted interim or
That is not reflected in my.
I think so.
I think 1 and 3 was granted.
Initially. Initially. The interim bail granted to the petitioner side order dated 13/8/2025 and um, 23/7/2025 shall continue till the next date of listing.
After vacation. On 15.
Next. Not really listen, man. Well, after some time, my file is with my junior now. Next. So you not receive.
He's on interim.
Interim. Is the not received issue recognition. Interim order by order dated 14/7/25 shall continue to the next date of listing. 15/10.
Yes.
15/10.
10 lost. 37, 15, 10 lost. Deep check.
Okay, in this matter, Lordship, by order dated 10/7/25, I was directed to appear before the IO Lordship, and accordingly I have appeared Lordship and record statement Lordship. And the matter pertains to Lordship 15 Lordship. All the offences charged Lordship under the NSS Lordship are punishable up to 5 years. Lordship. The FIR is at page 15. Lordship.
Anyway, so it has come. Seriously.
It has come. Although they have appeared, during investigation, it has come to the light that they were selling the same thing to different person. They were selling the same line to different persons. Those persons whom they have earlier
That's
tried
fraudulent activity.
the problem. The earlier person to whom they were trying to sell the land, so they was money, so their statements are also there.
If you want to make elaborate submission, then keep it for Monday. I'll extend it.
Yes.
You go through it.
Or
Some more time. What else?
All statements are here.
Because there's almost, huh?
On last occasion, Lordship, direction was there to obtain up-to-date CD on last occasion.
Then we need up-to-date CD, the direction, because the up-to-date is up-to-date DD 22/7.
28/2025. Lordship. Up-to-date CD was called.
It was sent back, it's come again or just not gone back?
Otherwise, it can be disposed of in Monday, except because materials are there.
Then we can have a look on Monday, then if we need it, then, okay, the case diary is received. However, full hearing could not be taken due to paucity of time. This is the matter on 15/9. The interim order, right order dated 10/7 shall continue till the next date of list.
CB.
Interim is there? Interim is there. Yes, diary not received, it should remain. Interim, bail order dated 28/7/25 shall continue till the next date of list. When do you suggest?
My lord, on 16/10.
16/10.
Okay.
May I please? The second time the bail, the CD was called for my lord, but you will find a file at page 11, my lord.
CD not received.
Nine batteries were, my lord, stolen, my lord, and that was recovered, my lord.
Batteries,
Yes, my lord.
solar batteries.
Solar batteries, and that I have also annexed the, my lord, Zimma order, my lord, at page 15, my lord. The Zimma had already been given to the informant also, my lord. Yes, my lord, at page 15, my lord. You file a Zimma petition and, my lord, seen and peruse the report sent by the IO of the incident case. It is reported as seized 9 numbers of battery solar power. Gen system was seized by the IO in connection with this case. The report also stated that the petitioner, namely so and so, is actual owners of the seized articles, and the article is no more required for further investigation of the case. Also seen and peruse the petition filed by the petitioner in Zimma of the aforementioned seized articles. Third, learned APP and learned counsel of the petitioner peruse the case. From the above, it is seen that the report of seized article is in the custody of the police station for considerable period of time. As per the report of the IO, the actual owner of the seized article is the petitioner, and the article is not required for further investigation of this case. And it has been given, my lord, to the informer. In this connection, one person has been arrested, my lord. He was also released on bail, my lord.
What is the allegation?
Allegation 9 numbers of excited batteries were stolen, my lord. And one person, my lord,
This is the AB. right?
AB, my lord. SPS 14, my lord. One person was arrested, my lord, Abbas Ali, and from his possession, these batteries were recovered, my lord, and subsequently he was enlarged on bail, my lord. So may I play for interim, my lord, so that my statement of recorded, my lord.
Is not a matter of.
It's a different thing.
Yes. Because
Zimma
the
is-
offense is here, kindly go to the FIR.
It can have a bearing in the sense that the
Yeah.
materials have been recovered.
recovered, my lord.
That must
That will depend on.
otherwise, I agree with you.
Here they have broke the premises, then they
These are-
have stolen the.
Serious matters actually.
And
But,
that other person, that person, he was given bail, regular bail. That very will not come.
Of course, he's not named in Aadhaar, but the thing that everything
Obviously, it
cannot
will
be
be
there
not-
in the Aadhaar.
Obviously, it will be not.
Certain things.
Look, it is probably recovered from the Abbas Ali, my lord, not by the petitioner, my lord. There is nothing to show that, my lord. So I'm paying for my lord, interim, my lord, so that his statement may be recorded, my lord.
My lord, hearing was consulted on earlier 2 occasions. They have a petition of a.
Because nothing is going to be hampered, my lord, if he has been granted. Already everything has been recovered, my lord.
When can we get the CD?
This is the second time, my lord. CD has not come.
On 22nd,
Second. Can it be a 19?
we'll try.
It will be, let us see. The case diary is not yet received. The learned counsel, the petitioner are praised for interim. This is the matter for bail hearing on 19/9.
This matter city has become in earlier 2 occasions.
It is not received.
In earlier 2 occasions, yes, it's come. So some date will be fixed.
Get the case diary. Isn't the allegation.
Murder.
The-
Murder. Oh, on 22nd.
This also you kindly try for 19.
I have no issue, but the only thing is that they have not already fixed lot of cases on 19.
May not reach.
They may not reach. 21 is sir.
You're for the informative. 21 is Sunday. Has to be either 19th or 23rd. You can adhere to VC also. No, I'm willing to accommodate you, but the thing is that 21 is a Sunday. But we'll have to be late for 23rd. It's on 23 now.
May you please, your lordship. You know, there is an interim of some lordship. The FI is at my lord at page.
PDS come.
My lord, CDS come, my lord. I will don't pay properly. My lord. My lord, if it is possible, my lord, we fix on 17th.
Wednesday. The case diary has been received, but one additional to seek some time to go through it. Prayer is a lot. Only one petitioner, five petitions, all are interim.
All are.
The interim protection granted by order dated this act will stand extended to the next date of listing. List on 17.
I would record as all four videos.
Scan. Look at proxometer.
Their time for report has been received. It keeps on next week.
TCR has been received. Read the matter on when you suggest.
Wednesday,
27, 79,
19.
19, 29. Okay.
6, 7.
May I please, your lordship? This is a pre-arrest period petition. And I want to interim. CD was called for.
Well, here we have received the city, but whether after interim or he is appeared or not, that is not reflected here. Up to that city.
Submitted that same,
Both are same.
is submitted by Mr. Kaushik Learned additional PP that though CD has been received, but it is not reflected as to whether he appeared and statement recorded pursuant to grant of interim pay. So what do you propose to do? Send
But I'm sorry, his statement is here.
there?
Yeah, statement is here. Otherwise, from the witness's statement, it has been found that he tried to give this money lending business. This and then my lord, this victim, he my lord took some he was unable to pay some pressurized.
He committed suicide. There's time constraint.
Yes.
I can. Reserve and then pass it later, but very there and address. You want to make submissions? Yes, who are there? Who are there?
I am for the account number 2, my lord, actually. Lord, we have a clothing shop, my lord. I have annexed the, my lord, trade license, because you will find at page 14, my lord, annexure 2 of my petition.
Lending at exorbitant rates, something like that. Lending at exorbitant rates.
But regarding rate, that's not.
That's not there. The money lenders act also is there.
Yes, because these are unorganized.
Please.
Yes, my lord, page 14 is the, my lord, trade license. My lord. We are running a, my lord, garment shop. My lord. We don't run on anything, my lord. We don't lend money on interest, my lord. But you will kindly see page 14, annexure 2, my lord.
Garment shop.
Garment shop, silk.
My father's name is there. It is owned by my elder brother, my lord, Pramod Nath. My father's name is Brodeswan Nath. It is there. In the cost title also, lordship will find my father's name, same my lord. So we don't run anything, my lord, and we don't lend money on interest, my lord. I'm a my lord, gentleman. I'm having a my lord, this cloth shop. I'm having reputation in my society, my lord. This is altogether, my lord, I blame my lord. This man, my lord, who is my lord, who is Sakam, my lord, he was a usual visitor, my lord, regular visitor to my shop, my lord. And because of on good faith, my lord, we landed, my lord, he had borrowed, my lord, an amount of his 1 lakh from me, my lord. But despite of repeated requests, my lord, he could not pay, my lord, a single penny, my lord. But now he is saying that his son is saying that he has a doubt that his father has committed suicide because of physical and mental torture provided by both the accused persons. This is altogether a false allegation.
Sir.
Kindly see in the FIR, my lord, the last 2 lines,
I've
page 10.
seen-
Yes, we have a doubt that because of mental torture, they have a doubt, my lord. This doubt can be, my lord, based on,
Vernacular,
this is on, my lord, based on prediction, my lord. Vernacular,
আমার
lordship,
সন্দেহ হয় যে
আমার সন্দেহ হৈছে, yes. আমাৰ সন্দেহ হয় যে উক্ত আসামীজন দুয়োজনৰ মানসিক অত্যাচাৰৰ টকা বিচাৰি কৰা শাস্তিত মোৰ দেউতাই আত্মহত্যাৰ পথ বাচিলে। This is their mere doubt, my lord. This is not concrete, my lord.
any, should I have a look or time? Mr. Z.
Z. Ahmad Mahmood, council.
Around question. Yes, second paragraph. Second paragraph. The learned counsel denies on behalf of the petitioner that they are running any money lending business. And in this regard draws attention to a copy of trade license indicating a cloth shop,
Silk alone, in English.
a cloth shop in the name of his father.
In the name of his, my lord, elder brother, Pramod Nath.
The name of Pramod Nath.
Yes, elder brother.
Some of the materials are there that he has indulged in this lending business. Allegation in the Aadhaar dated so and so. Aadhaar dated so. 19/7/2025, lodged by the son of the deceased, that his father had borrowed some money from the petitioners. And with regard to the return, he started exerting mental pressure, mental torture upon him. And subsequently he disappeared and was found dead on 16/7/25. He stated also stated in the Aadhaar that by the informant that they have doubt that because of some such mental torture, both the accused persons, such mental torture by the accused persons, his father has committed suicide. The case diary has called for has been received list to follow. Third, one is additional people. Statements of some of the witnesses. It emerges that it is revealed that many persons used to visit the shop of the petitioner seeking money and the petitioners used to talk with those persons outside the court. The aspect of whether any acts of the petitioner resulted in abatement of suicide of the victim would be a matter of evidence and at least further investigation. Therefore, at least states Therefore, I also find some force in the contention of the petitioner counsel that the other has been lost an element of suspicion about the petitioner's conduct being responsible for the death of the victim. You might consider the granting pre-arrest bail to the petitioners may not unduly prejudice the investigation, at least. Therefore, in such view of the matter, it is directed that the event of arrest of the petitioners in connection with this case allowed to go on bail of rupees 25,000 once you're at, subject to the condition that number one, yourself cooperate with the investigation and appear before they have appeared, statements report. They'll render cooperation to the remaining investigation, not intimidate or harass the informant or his family, not hamper or temper evidence. So return back is the petition's disposal. Deeply blessed. Both are same. Same, you have. I wanted to touch one hearing also. Yeah, but orders also could not touch. Mission also could not touch. Any submissions?
My pleasure, Lordship. My Lord, I have a small prayer with regard to item number 26, my Lord, of the daily list. Here I have selected the order by which my prayer for Jimmy was rejected. My Lord, the matter has been listed several times and the vehicle has been lying in the road for the last 2 years, my Lord.
26.
26, my Lord. May I pray that it may be taken up of Monday at 2 p.m., my Lord, if possible, my Lord.
So, again, not everything will come in the list chronology. Can get it fixed, but I don't know. Again, no guarantee.
My Lord, on Tuesday, my Lord.
That's what Monday.
Monday, my Lord. Oblige me.
Item in regards of item number 21, there is an interim order. Kindly consider and list after puja vacation.
21. Matter could not be taken up due to paucity of time. List the matter. Should I fix a date?
Yes.
On October.
20 lots.
Let it be on 22nd or 24th October. Which one? 22nd October. 22nd October, the interim order granted by asylum. By order dated ... shall stand extended till the next date of listing.
Lordship, item,
I'll come to it, don't worry. Yeah.
item number 24, Lordship. Lordship, the petitioner is in custody, Lordship, and I have challenged to order, Lordship. Can it be, Lordship, on Tuesday, Lordship, and he is in more than 4 months in custody, Lordship.
It is against conviction.
No, Lordship, and that is the Lordship, and order challenges Lordship the juvenile age. And I have already one more certificate has been submitted before the landed court below, Lordship, not consider, Lordship. On that basis, I have scored.
It would come up on any motion.
Can it
On hearing day.
Tuesday, Lordship.
Non-hearing day.
Lordship.
Hearings have to be attended.
Tuesday's hearing.
No. Hearing listed. Should I admit it and come it for hearing? Division, yeah, it might require full hearing also. And so if something can be disposed of at the inhibition state, it should be. But not at the cost of all hearings. See, more aware than me. So, 25, item number 24 will not be taken up due to paucity of time. These Tony's are listed there. One before is already piling up. Twenty-four. Earlier. 19. 19. I understand difficulty on the side also. Now we have more courts also still.
May it please, Lordship. With regard to item number 62, Lordship, from last 3 occasion matter did not reach lordship. I'm not
60
on interim.
62.
Yes. I'm praying for 3 years. Lordship.
Yes.
I'm not on interim.
You're not on it.
Lordship, can it be on Tuesday? From the last 3 occasion it did not reach.
16-9.
God bless.
Private mention item number 14, which is effective by the application, no entry mark. CD is available for the PPS in funds. Monday or.
Wednesday. Item number
14.
14 is. When do you prefer? 15 or
Monday, what is the?
17?
50 may retain.
Yeah, CD may be written.
May I please, Your Lordship? My lord, I beg to mention item number 22. Here is a interim order, my lord, who is staying, my lord, trial court proceeding, my lord,
I see.
till today, my lord.
Hmm.
Look, I pray that this matter will take some time
Mhm.
because this is regarding, my lord, sanction, from the point of sanction, my lord. It will be taken up, my lord, after vacation, my lord.
Yeah, should we admit it? Admit and
If it admit, my lord, hearing again, my lord.
on hearing they only come.
Yes.
If we admit it,
Yes, my lord.
admit but without seeing the file. Criminal petition 22. The interim matter could not be taken up with the paucity of time. It's stop. List. List after the petition on.
Can it be on 23rd, my lord? 23rd of October.
23rd
Thursday, my
of
lord.
October.
Yes.
23rd of October. The interim order granted by ... We'll see the file. Shall continue with the next step.
All right.
I declaration for item number 27. Scan copy will sit by this. So I'll do which one Tuesday matter. On 16th.
In this case, Your Lordship, I'm appealing for the petitioner, item number 27. There is an interim field to the.
You are for the
I'm for the
respondent. You for the petitioner. You want it to be fixed on Tuesday.
Any day, Your Lordship. In my respectful submission, there is no urgency as such.
Very urgent matter that the victim is seriously affected since 2008.
What is the matter?
There is two parts. One part compensation fine, all equipment given in the year 2011. But another part, no property has not been recovered. They are resisting, say, one after another plea has been taken.
Matter could not be
And
paucity of time.
Next part.
Our Islam Learned Council for the private respondent submits that there is urgency in the matter. Can it be on 18? Yes, is the matter on 18/9? I don't know, even 18 is.
Item number 19, whether the motion item. Motion item. Item number 19.
Okay, today, take up.
Yes.
Fix it another. When do you want?
Monday night.
Monday?
In the motion.
Paucity of time. Fixed on 15. It will come in the supplementary list.
Motion column.
Not the motion columns.
Hello.
May I please, regarding item number 63. As per order dated 4/8/2025, Your Lordship, I have been granted interim protection. After going through the case record, my Lordship, this court finds that there is no material damage to me. Is there a share of protection?
Paucity of time.
The case record.
Paucity of time. Another day we'll fix it. Because I have not seen, so not be better to reserve this.
CD sitting in written.
The case diary and record, case record also. Yes, yes. Scan PCR and case diary has been received.
Case diary also.
Okay, only case diary. Only CD has been received, maybe written. We'll fix it on.
Okay.
Interim bail is there.
Yes, sir.
Interim bail. While order dated so and so shall continue. Wednesday, 17th.
Back legal issue. Back legal issue. In item number, my lord, 51, my lord, that people a long time, my lord, city was not produced. And earlier occasion, your lordship asked them to take one status report of the matter. 51,
Which item?
item 51. Whether, my lord, it is charge sheeted or final report submitted, or otherwise, my lord, your lordship asked them to take instance of today. Next day, my lord, matter may not take much time, my lord.
Not be taking 51 paucity of time. Interim order is there.
No intent.
No. List on 23rd, 23 days.
It is a lordship, item number 5050. Lordship will be fixed to vacation before the appointment.
Any interim order?
As far as I'm
Fine.
aware,
For criminal appeal.
lordship.
Yeah, it was mentioned in the morning. But no. It was mentioned, but since it did not come up also, but okay. I might have forgotten also. So I don't know whether they took note after vacation. And he is on bail. Not sure. I don't remember what was submitted.
So as per the last order, there was supposed to be a status report regarding
No, after
Correct.
vacation I have written here, but reminder for something, he said.
this lordship
Reminder
of the
for something.
status of the appellants, whether they are alive.
Oh, is it? In terms of the last order, a reminder was issued for ... Said reminder is reiterated. List. After vacation, you want a date or just like that?
As per your convenience.
My convenience actually. People are having more inconvenience. For 15. On 28 October.
My lord, I beg to mention for item number 23, your lordship. There is urgency, your lordship. Let it come on next Thursday, your lordship. The opposite party repeatedly takes time to file affidavit. Today they filed it. So
Paucity of time. Learned council submits about urgency. Next on, you want next Tuesday?
next
18,
Tuesday, next
Thursday.
Thursday, your lordship.
18/9. 18/9. But the fixing is the easy part actually. It's not, the reaching is the bigger challenge. Fixing is the easy part. Reaching, I don't know, we have to go maybe faster in the day, or maybe we have to, all of us have to keep it short.
I find
Writing short, argument short,
Your lordship.
otherwise we'll never come.
It is also
Big challenge.
civil, your lordship. I filed a matter in January, your lordship, for quashing criminal proceeding pending in the court of permits. SDGM Morigaon, your lordship. The opposite party restrictively takes time to file affidavit. Today they filed affidavit. That is why
Try to hear it.
Thursday, your lordship.
Try our best.
Apply.
Anything else?